Yes. Hello, my beautiful friends. What an amazing day it is. Happy Friday. I hope your week was absolutely outstanding and you accomplished every single thing you set your mind to. And there's still time if you didn't. But we've got the Tyler Robinson, Charlie Kirk assassin hearing that is queued up, about ready to go. And we're waiting for the feeds to kick off. You can see we've got the Milwaukee Journal-Sentinel. And then over here on the other screen, we've also got a couple of other locations that are live streaming. It will be inside the courtroom. And we left off on the Charlie Kirk assassination case back in early December. It was another in-person hearing. And we had a big battle over whether we were going to close and basically lock this whole thing down, whether we were going to see the media kicked out, the cameras turned off, and all sorts of other things. Turns out the answer is no. The media was not going to get kicked out. But they were not going to be allowed to intervene on the case. So there was some shenanigans afoot. And you remember this previously when we looked at the docket. And there was all this closure stuff that happened back in October. And now we've kind of worked our way through the closure stuff. But what the judge ultimately ruled is that the media can file motions to say, if you are sealing something, if you're keeping something secret from all of us, then we can kind of object to that after the fact and then be heard before the public sees it. And we can make our argument the public should see it rather. And so we can see we got a full docket here and we'll go through. I think today we are probably going to touch on this. The last time we left off on this, we also learned that the defense team, Tyler Robinson's defense attorneys, were going to be moving to disqualify the entire prosecutor's office. Okay, not just one single prosecutor. Everybody, the entire Utah office has to go because apparently somebody's daughter was there on scene when Charlie was murdered. And obviously that can cause a little bit of trauma and PTSD and other things. And so the defense is saying that the prosecutor's office is biased and partisan now because the entire investigation has been tainted by this conflict of interest that has emerged. So we've got all those documents queued up here. And depending on when the judge comes out, they're usually pretty timely on this. We even got Fox News is out there reporting from on scene. In fact, let's go over there right now and listen in.
That they are putting a lot of focus on this. It seems like the disqualifying elements are what they're searching for at this point in an effort to try to defend this person who has a ton of, and I think we have a shot of this now. Let's go right to it. Who has a very difficult hill to climb in proving innocence. Let's watch this.
Good afternoon as well. All right. Before we turn to the defense's motion, the court would like to address four preliminary matters. First, in regards to the transcript from the December 11th hearing. Counsel, I would appreciate your input regarding the transcript from the December hearing. The transcript has been designated as private and copies are available to the parties. Consistent with the court's prior handling of the October 24th transcript, the court intends to release a redacted version of that transcript, but I want to get your input before making a decision.
Judge, we intended to do that as well. We haven't stipulated, we haven't come together to stipulate on a version of that transcript that should be redacted. We certainly can do that, and we're happy to do that.
Thank you, Mr. McBride.
We will meet and confer with Mr. McBride and his colleagues on that.
All right. How much time is needed by the parties?
2 weeks.
That's fine. A couple weeks.
All right. A couple of weeks, and then we can address that. Next, I want to turn to address media coverage and place on the record the potential consequences of any willful violation of the court's December.
Just making that full screen for us.
Under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. Any alleged violation will be carefully evaluated, and the court will impose only those sanctions which are appropriate and proportional under the circumstances. The court will make specific findings on the record before imposing any sanction. In addition, the court may impose the following remedial measures if warranted. First, immediate suspension of video transmission of the hearing, with proceedings continuing on audio-only basis for the proceeding where the violation occurred.
Don't do that.
And disqualification, if necessary, and narrowly tailored of the news organization that filed the request in order for electronic media coverage of court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter, where the court determines that such a measure is required to ensure compliance with a standing decorum order and to protect the rights of the parties. Counsel will be allowed to provide their input before the court makes any final determination regarding sanctions. I want to emphasize that these measures are not intended to have a chilling effect on open and transparent courts or on responsible news gathering, and the court remains fully committed to the presumption of open proceedings under applicable rules. Rather, they're intended to protect the constitutional rights of all parties while preserving the integrity, openness, and fairness of these proceedings. Third, at this time, I wish to address the camera operator. Mr. Yulberg, if you wouldn't mind coming forward and standing at the lectern.
Oh, shoot, cameraman. Called out.
And could you state your name for the record?
John Yulberg.
Thank you, Mr. Yulberg. It's not my intention to cause you any embarrassment or discomfort. I simply want to ensure that the guidelines for today's proceedings are clear. Mr. Yulberg, during today's hearing, what is your primary role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd, 2025 standing decorum order?
Yes, sir.
Do you understand the guidelines as they relate to your responsibilities today?
I do.
Do you need any additional time to review the December 23rd, 2025 standing decorum order, or any time to reposition the camera to ensure full compliance with those guidelines?
Don't get his
Do I
hands.
need more time? I'm sorry, was that the question?
Do you need more time to review the decorum order? And I'll pause there because that was a compound question. Sorry about that.
No, I've read it, I fully understand it, I'm good to go.
All right, to the second part, do you need any additional time to reposition the camera to ensure full compliance with those guidelines?
No, I think we're in a good position now.
All right. Mr. Yulberg, do you anticipate any difficulties complying with the December 23rd, 2025 standing decorum order?
I do not anticipate any problems.
All right, and is there anything that the court can clarify to assist you?
No, I think we're good to go, sir.
All right, thank you, Mr. Yulberg.
Man, shout out to our
Before I
cameraman.
let you go, I'll turn to counsel based off the questions asked. Turn to you if you have any input or questions.
Nothing from the state.
Thank you.
No, Your Honor.
All right.
All right, so can't have
All
him in
right.
shackles.
And the court, I appreciate your cooperation, and it's my hope that we all do our very best today together.
Absolutely. Thank you.
And finally, before we turn to the issue, the motion before the court, to the state, could you please provide a brief update on the status of discovery disclosure?
Yes, Your Honor. I don't have the percentage of materials that we have that have been disclosed, but I think we're above 90% at this point.
Wow.
There still is discovery coming in. There are reports and so forth coming in from various entities. So I think we're moving expeditiously towards completing at least this initial batch of discovery. Of course, discovery will be ongoing probably for the duration of the proceeding, but we have provided nearly all of what we have to date.
All right. And to defense, any input?
Not this time, Your Honor.
Thank you, Ms. Nestor. All right. Thank you, counsel, for your patience as the court covered those preliminary issues. Let's turn to the defense's motion to disqualify the Utah County Attorney's Office. Ms. Nestor, Mr. Novak.
That's fine, Your Honor. That's okay. We actually have some preliminary things we want to discuss with respect to the posture of this motion. And I also think at some point the court needs to decide at what stage the hearing on this motion remains open and becomes closed. So I'm going to bear that in mind in terms of my preliminary statements, if I may. When we filed this motion to disqualify, and when I say we, I mean Mr. Robinson's counsel, we fully expected that what the Utah County attorneys would do is refer the motion to the Attorney General's office so that the Utah County attorneys are not in the position of representing their own interests as potentially conflicted attorneys in a potentially conflicted office and representing the state's interest in the prosecution. We heard informally from the state's attorneys that they were preparing a response and when it would be provided. And then what we received, and again, I'm bearing in mind that we're in an open hearing at the moment, was a brief where I'm going to say the unsworn representations of two attorneys from that office are basically integrated into points and authorities. We don't have affidavits from Mr. Gray or from the other attorney. We have argument. We noted in our reply that we were surprised, that's in footnote 2 at page 4, that the Utah County attorneys were representing themselves in connection with a motion alleging that they have a conflict of interest and that the state was not being represented through the Attorney General's office. We did some further research on this, and you know, we have some case law that we can provide the court. I suspect that the court is very familiar with the fact, just from its own experience, that in appropriate circumstances, the Attorney General's office can either, one, represent the state in what was a county prosecution with respect to a disqualification motion so that the boundaries are clear, or if there's an ultimate finding or conclusion that there is a conflict of interest, take over the prosecution or assign it to another county. So we're very concerned that we're getting off on the wrong foot, if I can use that metaphor, because we have officers of the court who are both representing their own interests in continuing to be the prosecutors in this case and representing the state in a situation where there should be what I would call, at least temporarily, conflict counsel. I'm not sure that's the term the Attorney General uses, representing the state's interests. There's a Supreme Court decision which is called State v. Jimenez, Jimenez, which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the type of a case. I'm not saying that Jimenez compels that action, but it seems to me to strongly suggest that where there is a showing, I'm not sure what the threshold showing is. I don't want to say it's a prima facie showing or a reasonable concern, but where there's a showing that there very well may be a conflict of interest that hasn't been handled by a particular state attorney's, county attorney's office, that what's in the interest of the litigation, of the public, of the parties, is for the Attorney General to step in. And the citation for State v. Jimenez, if I may, is 588 P. 2nd 707. Of course, I can provide the court with the Utah citation as well. This court actually has the authority under that case, State v. Jimenez, to direct the Attorney General to step in, not for the entire case at this stage, that's not what we're saying is necessary, because that requires a finding of a conflict of interest, but to step in or to designate somebody to step in for the purposes of litigating that motion.
Yeah, even today, like they shouldn't be here arguing this if they're the prosecutors.
And so we're very concerned that even going forward with an evidentiary hearing where members of the Utah County Attorney's Office are both litigating as representatives of the state in a prosecution and essentially defending their own propriety of proceeding in this prosecution is problematic. As far as being prepared, we're of course prepared to go forward with an evidentiary hearing, but we think that it's improvident, and we think that what the court should do if the Utah County's attorneys have not or don't, if given the opportunity, do this on their own, is that the court should designate the Attorney General's office for the purpose of litigating this motion. The court might ask, hypothetically, the question, has the Utah County Attorney's Office conferred with the Attorney General about this particular question? And we are not in the dark, because as Ms. Nestor will tell the court, as an officer of the court, she's spoken with the Attorney General's office, and they have not been consulted about this. Okay? So this is a motion to disqualify a county attorney's office based on what we believe is a material, significant conflict of interest that it's clear they haven't even tried to address by way of a screening, which of course is a term of art, because their position is no screening was necessary. We're not even here to discuss whether the way in which a particular attorney was screened off was adequate. Their position, as their own advocates, is we've already decided no screening is necessary. So we've been told by the Attorney General's office, Ms. Nestor can represent to the court exactly what she was told, but basically that there has not been consultation. And while that is Mr. Gray's prerogative, we think it's wrong, and we think that this court needs to exercise its authority to intervene and say, in this case, for this kind of a motion, the court needs to hear from a representative of the state who does not even appear to have a conflict of interest. So,
Got it. They can't represent themselves.
That's our preliminary statement about these issues. And again, I hope I've avoided saying anything that should have been said in a closed hearing. I think I was pretty good about that.
You were great.
So that's where we are before we even get into the litigation of it. And I don't want to be formalistic, and I'm certainly not trying to be confrontational, but I think actually what we think the court should do is the court should strike the Utah County Attorney's response to our motion and direct the Attorney General to take up the responsibility for responding to our motion in whichever way clearly non-conflicted attorneys representing the state
So the whole hearing
think they should,
would be blown up right now.
how it should be responded to.
Because no one's there
And if
for
I've
the AG.
muddled, I always say this, Your Honor, if I've muddled anything or confused anything, please say so, and I'll try to clarify.
Thank you. I do have some questions for you as it relates to this. I wish to consider all the authority that you wish to cite to. I mean, obviously, you came into this hearing knowing that this is something you're going to present, and this court wants to be efficient with time, but thorough.
Yes.
And not jumping to conclusions. Can you give me all the authority that you wish for me to consider in considering your request today?
Yes, and I think what we could also do, which maybe would be more helpful to the court, is that we could file a short brief on this particular issue, because I will acknowledge that while we were surprised that the brief was filed by the same lawyers who are alleged to have this conflict of interest, it took us a little bit of time and we wanted to get that filed in time for today's hearing because the court had set the hearing. It took us a little bit of time to think through these issues.
So Judge is asking, why didn't you bring this up before?
There are authorities from other jurisdictions. There are also ABA guidelines on the prosecutorial function, which we think strongly suggest that there should have been what I'll just call a referral to the Attorney General's office for this particular motion.
And
I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot.
Yeah.
To require the court to, like go back into chambers, think about it for,
but we didn't know
some
until
pressured
they
period of
filed
time
their
to come back out and
response.
make a decision.
Then we realized it was
it
them.
would benefit the court for us to file something, and I don't mean in a month, I mean very soon,
Like now,
so that
right
the court
now.
has thoughtfully presented points and authorities. We're happy to do that. As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself. So I'm thinking about the convenience of witnesses and the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court is open to receiving authorities,
We'll brief you,
that we
then we'll come back.
recess this hearing for,
Yeah.
whatever meets the court's schedule, whether it's a week or 2 weeks or a few
Why
days.
didn't you
and
submit
we can
that
divide the
before?
court or something, and we'll come back. But we do think this is a serious issue, because I think the
Guys.
question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right.
Thank you.
Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that the court would be in this position based off of your request to prepare the court, prepare opposing parties, and to
100%
be
right.
efficient in our use of time? I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what the court does.
I hear what the court's saying, and I think we can take responsibility for not sufficiently presenting the authorities that we think compel what I've just suggested should happen. We noted in our reply brief that the county attorney should not be representing themselves. And that's probably an inadequate message to the court. But we did file a motion to disqualify.
8 days ago. You filed that 8 days ago.
Inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflicted, appropriate prosecutorial authority, which, as I've done further research, and Mr. Byrd and Ms. Visser and Ms. Nestor and I have all done further research, literally up until earlier this morning, we think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue.
Yeah, but they responded. They replied to your response.
So I'll fall on my sword if the court thinks I should be sanctioned for not bringing this up sooner. I hear the court, but we are we're juggling many aspects of this case all at the same time, some of which the court is aware of, some of which the court probably is not aware of. But the court can imagine.
Okay,
No,
county.
I appreciate that. It's not the intent to sanction you. I understand that issues come up, and there's a lot going on. And so the court appreciates your candor and representation today. So these items can evolve. And so the court is not finding fault with you. It's just hoping that as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party and for other parties, we just might want to make sure we make the best use of our time when we're together.
And they knew back on the 10th. When
I hear everything the court is saying.
Prosecutors responded.
I take it to heart. I understand what the court's saying, and we are cognizant of the time that the court devotes to preparation for these hearings. So that's all I can really say.
That's right. And also for Mr. Robinson himself and the victim representative, Ms. Kirk as well. We just want to do our best, and I understand. And I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happens.
Now
so
you want
I
to
understand.
Recess this?
I'll turn to the state. Oh, and I'm sorry. Is there anything further that you wish to represent?
No, I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court
I don't think
a list
the judge
of
is going to
verbal citations.
disqualify
I think
so. If the hearing goes
with
on, he
all
won't disqualify.
consideration for, and we probably have, with all consideration for the fact that the court wants to be thorough and careful, and we do as well. We don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way once we understood not only the way this was developing, but, frankly, the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and the information that we received today from the Attorney General's office, which isn't a secret. It's just we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll go ahead and take those authorities right now. If you'd like to list them. Court is ready.
Feels like a little
the
bit of a
second one would be
stretch here
State v. Robertson, and that is also a Utah case 886 P. 2nd 85. There's the ABA prosecution standards. I would refer the court to section 3.1.7 and 3.2.5. And those are, I think, the places to start.
Is there any Utah rule on point that addresses this issue?
So the case of State v. Jimenez, which I referred to, which is the Supreme Court, does actually cite a statute.
Okay. Anything further that you wish for this court to consider at this point in the proceeding as it relates to this issue?
No, and depending upon the statements of counsel, we may have some response if the court permits it.
Of course.
Right.
Thank you. Turning to the state. Mr. Gray.
Your Honor, I'm not sure why this is coming before us today. If it was such a surprise to them more than a week ago, I don't know why they wouldn't at least notify the court. I, too, represent the state. I'm an elected official, constitutionally elected to represent the state. Where does this end? I don't know these cases. I'm very interested to see whether or not they refer to trials. I know that the Utah Attorney General's office, they've done the same thing that we have in Rule 11 motions, where one counsel on the team examines their boss, in fact, on the matter. So I just think this is ambush and another stalling tactic.
Feels like that.
To delay these proceedings. There's no reason that they could not have at least filed the motion and asked for time to brief it. And where does it end? Do we get to respond to their motion to have the Attorney General's office respond, or does the Attorney General's office have to respond to that one too?
Then you have to have a hearing on that too.
I'm not, well, anyway, I've stated my, it should have been done far earlier if that was their case, if that was their claim. And if I could just turn the time over to Ryan in case he has something else.
Thank you, Mr. Gray.
All right, so the Maine County Attorney,
And
the big
excuse
guy
me,
here.
this is, we're tag teaming this somewhat because it's a surprise to us as it is to the court. But in the 5 minutes I've had to read Robertson and Jimenez, which could have been provided to me before this hearing, it looks like those cases don't stand for conflict of interest cases. They're actually, does the Attorney General's office have authority to prosecute cases that occur within a prosecution district or county attorney's jurisdiction? And the answer is yes. It's not about taking conflicts from the few minutes I've had to read those cases. I do want to state this is, of course, the first time this has been raised to us. The defense has known that we were going to respond to this motion for some time. We requested an extension for our filing deadline back in December. The defense agreed to that extension. Our reply was filed January 5th. The defendant's reply was filed thereafter. And in that reply, the tone of that reply is mentions that they thought that perhaps a special prosecutor would be appointed to handle the conflict case, but in the alternative says we'll be able to, we want to subpoena witnesses to establish the facts that are laid out in the state's opposition motion or memorandum. And that was what we understood was going to happen today. You have a family member of a prosecutor who has been subpoenaed. An affidavit has been supplied to the court. We believe that affidavit is adequate, but it wasn't adequate from the defense perspective, so they subpoenaed that person. Prosecutors have been subpoenaed for today's hearing. We have 2 investigators that have been subpoenaed for today's hearing. And we are ready to go, Your Honor. I think that the motion or the request that the defense has made assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true. If there is a conflict, which is the question that this court is to decide, the case will be referred. Until that conflict has been established, the case is properly in the jurisdiction that has statutory authority over that offense. And until that conflict has been established, the Utah County Attorney's Office has this case and can defend its involvement in this case. I got just a moment to review my notes and see if there's other points we want to make on this.
Of course.
Little surprising there's not just a clear statute on this. Once one side makes the allegation, the other side has to do this, delegate it to someone else.
There is one other point I wanted to make, which is the idea that the case would be referred, that alleging a conflict would cause a special prosecutor to be appointed.
Right there.
That really assumes that there is a conflict, and until that conflict has been established, there is no duty for the case to be referred to another jurisdiction or another special prosecutor to handle. And it raises some of the issues that have been brought up in some of the case law regarding creating or alleging conflicts. There's a lot of case law that talks about how it can be a tactic to try and remove cases from one prosecutor's authority to find a more lenient prosecutor, find a more favorable prosecuting authority that's not going to seek, for example, in this case, the death penalty. And there's a lot of case law that talks about you can't call opposing counsel as a witness in a case unless they're absolutely necessary. And the reason is because it can be a forum shopping effort. And we're concerned with that same kind of motivation or tactic that could be used in this case or other cases like it. Anytime you, as opposing counsel, you don't like the offer you're getting, the way the prosecution is being handled,
conflict.
You allege a conflict of interest, and all of a sudden the county attorney's office has to spend $10,000 to hire a special prosecutor just to handle that one issue, regardless of whether or not it's supported or whether or not a conflict exists. That's a concern we have. Your Honor, we're ready to go forward today. We think the evidence that will be presented today will illuminate the issues adequate that Your Honor can make a decision about whether or not a conflict exists, and we don't need to delay this proceeding any further. We're confident the court will see the facts as they are and be able to make that determination.
Mr. McBride, so the motion has been made by defense to continue this hearing to allow the filing of a motion addressing more fully this issue.
Don't do it.
To that request, what is the state's reply? We
object to that motion to continue or to strike. We ask the court to go forward today. We think the motion is untimely. The court has, or the prosecution has subpoenaed witnesses, and every delay that happens, the witnesses that we have now family members of the prosecution being subpoenaed. These people are ready to move forward and get this out of the way. The longer we delay this, the more anxiety that this procedure has.
All right. Thank you, Mr. McBride. To defense, any response?
Yes, John, thank you. First, I want to say this is not about seeking a lenient prosecutor. This is not about tactics at all. And it was actually the county attorney's office who informed us back in October that there was a family member of a prosecutor who was present at Utah Valley University at the Charlie Kirk rally and experienced and witnessed certain things. We didn't make this up out of whole cloth. We didn't grab onto some piece of discovery and say, a wedge, a tactic. The Utah County Attorney's Office informed us in late October that we needed to know about this, and we informed them, fine, that's your position, it's not a conflict of interest. We think it is, and we intend to litigate it. So it's not a tactic, it's not something that we've made up out of whole cloth because, like I said, we found a needle in a haystack. It's something that they properly brought to our attention, but we firmly believe that the law supports the conclusion that that particular prosecutor should have been screened off. There's good case law on screening, which we did fully cite in our briefs in a timely way, and there was no effort to screen off that prosecutor, and that has now created a problem for the whole office. That is not made up out of whole cloth, and like I said, it's not about tactics or lenience or delay. This isn't delaying anything.
Why do they need the AG to represent them, though?
The other thing that I want to point out is to say that until this court decides there's a conflict of interest, somebody else shouldn't be handling this issue is circular. Because by that point in time, the court would have already allowed the conflicted attorneys to represent the state in a hearing on their potential conflict. So I actually think the way you avoid that circular argument and the sort of harm that arises if the court were to find that there is a conflict is to at least temporarily have the Attorney General's office handle this.
There's got to be authority on this.
Yes, Judge? Mr. Gray is an elected official, but that doesn't mean that his office doesn't have a conflict of interest. Conflict of interests arise. A judicial officer decides to become a prosecutor. A prosecutor decides to become a judicial officer. That's actually where most of the case law comes from, as Your Honor knows. A defense attorney changes careers and becomes a prosecutor. There has to be a screening. The case law is very clear that the screening has to be adequate. There's been no screening here because Mr. Gray decided we don't think there's a conflict of interest. And what we're saying is it's not a needle in a haystack. It's not a tactic. It's not a fiction. It's not a thin reed. The evidence that the court has suggests, number one, but there's a very good possibility that as a legal matter, there's a conflict of interest. That's why we need to have an evidentiary hearing, because the court doesn't have all the facts. And number two, that the Utah County Attorney's Office, because they decided early on, without consulting with anybody, that they didn't have a conflict of interest, didn't put any screening mechanisms in place. And so I understand that they want to defend the decisions that they've made. But the question is, shouldn't the state be represented by somebody else in the course of this court resolving whether those decisions were right? Because to quote the law and to quote the ethics, the Utah County Attorney's Office is now serving two masters. I don't like that word, but that's the word in the doctrine. They're representing themselves and they're representing the state of Utah. And that's why the Attorney General or somebody else designated by the Attorney General should be representing them in this matter. And I do want to say one more thing, if I may, Your Honor, and I appreciate the court's patience. I think that the way we raise this issue in our reply brief is not as accommodating to just letting it go as counsel suggests. What we said is we asked the question is whether it is even appropriate for the UCAO to litigate this issue on its own behalf. While the UCAO may have provided this court with the information that it has deemed relevant to this issue, the scope of the disclosures and litigation of this motion should have been assigned to another state agency, such as the Attorney General. We didn't suggest that this court should appoint a special prosecutor for all purposes, or that the filing of this motion means that the Utah County Attorney's Office is automatically disqualified from the litigation. That's the point of the motion, is whether they had a conflict of interest, and if they did, whether they handled it. And it's our position correctly, and it's our position that the answer is yes and no. So I understand there are witnesses here, people are ready to go. We think that the court should either accept briefing or agree with us that the referral is appropriate. And I want to cite, if I may, the citation by the Supreme Court in Jimenez.
Authority.
So this is 588 P. 2nd. It's 707, but this is at 708. This is the statute quoted by the Supreme Court. If at any time after investigation by and a finding and a recommendation from the district judge involved that the county attorney in any county is unable to satisfactorily and adequately perform his duties in prosecuting a criminal case without additional legal assistance, the Attorney General shall provide such assistance. That's very broad. What that means in this case is it's inappropriate for the Utah County Attorney's Office to represent itself when it is also representing the state. And that for this motion, this court has the discretion, we would say, respectfully the obligation, to designate the Attorney General to represent the state, the people of the state of Utah, in this motion.
So the judge screwed up.
And depending upon how the court rules on the motion, then we have to see what happens next.
So is it your position that the court has discretion to make that decision?
I think that the court has the discretion to say to the Utah County attorneys, you shouldn't be representing yourself in this case at this stage as to this motion only. Continue to do what you do while this motion is pending.
Why would it be discretionary?
And we will resolve this motion. I am not suggesting that they should stop the work that Mr. McBride talked about preparing discovery, having their agents interview witnesses. We want to get this motion resolved in a timely way. It is not a stalling tactic, but I'm not saying, let me be very careful because I don't want to misinterpret the court's question.
They do kind of have to
I'm not
stop work,
saying
right?
that whatever this court decides is the right decision because the court has discretion. We believe that the law requires that the county attorney's office be represented by somebody else for this motion. What I'm saying is the legislature gave the court the authority to compel that when the state attorney and the attorney general haven't done anything about that yet. I'm not saying that the court, I mean, I don't know what the standard of review on appeal would be, so I'm not just saying it's an abuse of discretion standard. What I'm saying is the legislature gave this court the authority to direct, refer to the attorney general representation in a criminal case where there's a showing of a potential conflict of interest.
So it's the judge's fault.
I've been a criminal litigator, although on this side for a long time. So I understand what counsel's talking about is sometimes defendants come up with questionable grounds and move to disqualify. And I don't think that that's a finding that the court can make in this case. It was actually, as I said before, the Utah County attorneys who were concerned about this enough that they brought it to our attention. We have profound disagreements about the significance of the conflict and the way it was handled. Okay? Right. And otherwise, I think I would be repeating myself if I said anything more without answering a direct question.
From the judge, maybe?
All right, I do. I just have a brief question. Do you have your witnesses here today?
All the witnesses are here. We have no problem as a pragmatic issue going forward. Our witnesses are the subpoenas that we served, which were filed with the court.
Okay.
So to be clear, I don't think the court is inferring this. We're not unable to proceed if that was the court's conclusion. We are prepared, and the witnesses are here. I'm just saying we think that it would be improvident and it could result in errors of law, and it could result in problems down the road.
Uh-oh.
Thank you. Do you need any additional time in regards to your argument to continue this hearing based off the citations you've provided, the authorities you've provided the court?
1 second.
Yeah, so basically the judge screwed it up. The judge should have taken it from the current county attorneys and given it over to the AG, or said in an order, I order the AG to respond to this.
No, thank you.
All right, thank you.
Didn't. So the reason we're all
what
here.
What this court intends to do is, this is an important issue, and I realize the totality of what's been presented. And my question in regards to your witnesses is, it was informatory. I just wanted to see if depending on what the court rules, if the parties, I don't want to disadvantage either party in that. So this is an important issue, and this court wishes to take a brief recess. I want to look at what's been provided and make see where the court needs to go. I want to inform myself, take a moment to look at it, and as opposed to just making a snap decision and taking into consideration all parties and the constitutional rights of all parties as well. With that, we will be in a brief recess. I always hesitate to give a time because sometimes
we'll be here.
I appreciate you being here. Court is in a brief recess. Thank you.
All right, so that is a very interesting development. When I was speaking, I was talking about the docket and running through kind of the timing on this and how the defense knew that the Utah County Attorney's Office was going to be participating in the response because they submitted their opposition back on the 10th. That's 6 days ago, right? So in other words, the defense knew that the county attorney was writing motions and responding to these things. So they should have responded to that back then 6 days ago and said, hey, what are you guys doing? You can't respond to the brief like this. You should have had the AG, and they could have filed a motion, and the judge could have reviewed everything and then come back down and said, oh yeah, you guys are right. Actually, I will now at this moment go appoint the AG to come out here and step in and get involved in all of this. But that didn't happen. And so here we are. We're now on the 16th, and the judge is taking it under advisement. So what we're going to do is pop out this video. Further live coverage is expected. Perfect. And so we're going to open this up, and then I'll show you the motions that we're talking about, what we're battling about in the court itself. So here is one filing. Now, this is what we're kind of getting into here. This was the opposition that was submitted from the prosecutors over to the defense that they're all upset about now. They're saying, wait a minute, how can you even respond? You can't represent yourself. You should have gotten the AG to come in here and file this for you. But this is a 33-pager, and this shows you this is a pretty heavy one. And if you go all the way down, maybe to the bottom, let's go to page, 20, let's go to 28, and I'll show you the text messages that they discuss inside. So the affidavit of Cole Christensen, and then here are the text messages that came in from the daughter, and then we'll go into the actual substance of the motion. And of course, once the judge comes back out, we'll get back into that. So here's the messages between daughter and prosecutor of the Utah County Attorney's Office. Daughter sends to dad, someone got shot. I'm okay. Everyone is going inside. Next minute, Charlie got shot. Oh my gosh, ... People say he was shot in the neck and his head like tilted or something. What the heck? Insane. We had answered one question. He had answered one question and was talking to the next person. Is it confirmed? Like, is he dead? Dad, blank, did you hear a gunshot or what sounded like a gunshot? Dad responds, what? Oh my heck. Someone was there. He said they found the shooter and put him in a cop car. No, they didn't. Daughter says, I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck. Not sure. I left my bag with all my stuff because I didn't have time. Facepalm. Shooter was on the roof, says dad. Daughter, doesn't surprise me. The weird thing is the guy asking the debating him in the moment was talking about shootings in the U.S., I think. The guy debating him corrected. I am getting live information, but I can't share it right now, says dad, who is a prosecutor in Utah, who's talking to everybody. Daughter says, dad says, so-and-so, my uncle, said he was in the roof. Someone posted a video of the shot on Twitter. His head tilts to the right. Yeah, I saw it. It's from way far away. Yeah, that's what people were saying. I think this is still daughter. The video is horrible. The close-up one is sickening. He's gone. OMG. How do you know? And it feels like we only got one half of the conversation. How do you know? How do you know? The close-up video shows a direct hit to an artery. Blood immediately shoots out. Sickening stuff. Yeah, unbelievable. Yeah, I watched it. Looks like he died instantly. And yeah, it was very brutal. Horrific video. And important to know what these people are willing to do. And so here is what the motion ultimately said. So requested disposition. This is from the prosecution saying, yes, my daughter was there. Doesn't mean you should disqualify the entire county. Explaining, defendant argues that a member of the prosecution team, one of the deputy county attorneys, so Tyler Robinson, is saying one of you guys has a conflict of interest. And because of your conflict, the entire county has a conflict and that everybody needs to be disqualified. They say, no, judge, you should deny their motion because there is no personal conflict of interest at all. And even if one did exist, it doesn't extend to the entire office and you don't have to disqualify everybody. Now, the defense is bypassing this entire argument. They're saying, we don't even care. You guys can't write this for yourselves. Kind of like if you're an FBI agent and then the FBI goes and investigates themselves and they find they did nothing wrong, you're like, pfft. Or the Secret Service are like, no, it was a great event. Butler was great. Can we investigate yourself, you guys, and see, how you fail to protect the president from getting shot and other people in the crowd from getting killed? You say, no, we investigated ourselves. No problem at all. Leave us alone. So any testimony, they say, right, from the child could be merely cumulative testimony. There were thousands of other people there. She has no personal knowledge of the matter or the murder. So there's no bias to Tyler Robinson because daughter was there, like passing dad inside scoops. Moreover, AC's, the daughter, comparatively minor emotional reaction could not have had any greater impact on the dad then other more harrowing experiences from others at the event. So yeah, daughter was there, daughter was shaken up, but the prosecutor is going to be as impacted by somebody who's not his daughter, who is way shaken up. Somebody who's right there, somebody who may have blood on their hands or front row or whatever. So they're saying, yeah, the prosecutor as a prosecutor is not going to be persuaded one way or another. He's going to be highly motivated with or without his daughter. So it's not like a vindictiveness that is emanating from this experience. And saying prosecutors may consider these things, by the way. We're allowed to consider witness reactions, even if it is my daughter. And finally, the filing of this and the death penalty that we're looking to seek here had nothing to do with the daughter being there. It's not like dad was like, oh, okay, now this guy's going to die for this. More background from the prosecutors. They say on September 10th, Charlie Kirk was at an outdoor forum in Utah Valley University when he was shot and killed. Prosecutors say he sat on a stool under a tent at the bottom of the amphitheater, facing the quad's center, where a microphone was set up a few feet away for attendees to debate him. Some 3,000 people were there, sitting or standing above Charlie Kirk in and around the amphitheater's tiered seating. And this is also a weird thing, right? Charlie Kirk was at the bottom of like a pillbox. And if he's also under cover of the, whatever that is, it was like a stand-up tent, essentially. And somebody's on the roof and he's down under the ground level. Feels like that's a real steep angle to get to from a roof, to get under the tent, right? So anyways, 3,000 people were there, many sitting or standing above Charlie. And among the attendees was the 18-year-old child, a college student at UVU. Now, the daughter was standing on the far right side of the amphitheater as you look down on its upper edge, some 85 feet away from where Charlie was seated. And we have a diagram of this, so let's just hop down over there and see what we've got. Let's enter that number, and you can see they gave us a diagram right here. I think they're going to come back to this, but they're marking, I believe, where Charlie is right there on the X. And he was, down. So we'll come back to that. Let's go back to the prosecutor's statement. They say, what happened was 85 feet away from where Charlie Kirk was seated is where she was, on its upper edge. Now, there was no line of sight between AC from her position and the shooter from the position at the Lossy Center. And let me see if I can get rid of this better so we can kind of see our screen. It says, okay, so no direct line of sight because the Sorensen Center stood between them. She would have had to have moved 75 feet to the southeast before establishing a line of sight with the shooter. So she couldn't even see the shooter. So I think that also implicates, could she have been killed? No, the shooter couldn't have even physically hit her because there was no direct line of sight. So at 12:23, Charlie Kirk fatally shot and killed. He was answering a question posed by the second questioner in the audience. Text messages go by. AC, quote, did not see Charlie get shot. Before the shot was fired, AC had turned her gaze, I'm sure, away from Charlie Kirk and was looking around at the audience. As AC was looking at the audience, AC heard a loud sound like a pop and someone yell, "He's been shot." When everyone realized that there was a shooting, attendees crouched down. After a few seconds, people started running away. AC then followed suit. AC ran into the building behind AC, entering through the building's doors just northwest of AC. She never looked back at Charlie Kirk and thus did not see him get carried away. Also did not see anyone else in the crowd with a gun or think anyone else was even involved in the shooting. Now, even after running into the building, the prosecutor's daughter did not know what really happened. Heard that someone had been shot, so she sent 2 text messages to the family chat group. Okay, so maybe those were other family members kind of in sequence, which included her parents, siblings, and their spouses. Those 2 text messages to AC's family read, "Someone got shot. I'm okay. Everyone's going inside." Now, after someone in the building told her that Charlie Kirk had been shot, AC sent a 3rd text message. "Charlie's been shot." Screenshots of those text messages attached. We just read them. When Charlie Kirk was shot, the deputy attorney was with county attorney Jeff Gray at a conference in Ogden. The deputy attorney first learned of the shooting when he read AC's text that Charlie got shot, told the county attorney that right next to him. It's like, oh, my daughter was there. She just got shot. So deputy attorney then left the conference 10 to 15 minutes later, drove to the law enforcement command post that had been set up at UVU. Gray did the same thing about 20 minutes later. Now, what is more, as in other murder cases, other county deputy attorneys would be making their way. Over the next 2.5 days, deputy county attorneys Ryan McBride, David Sturgill spent most of their days and some nights at the command post, assisting with search warrants and providing other legal counsel. Now, although the daughter, AC, was scared at the time, she has not had any lasting trauma from the event, has been able to continue on without any emotional problems, has not needed counseling or therapy, has not missed any classes, not missing work, not missing any other normal activities. So now the county attorney, the guy we just heard from, in his decision to file a death penalty notice on the same day, had nothing to do with her being there. He filed the notice immediately because he determined that the evidence around this aggravated murder is substantial. He ran for elected office almost 3 years earlier on a commitment to seek death penalty cases and bad cases like this. He also learned in another case, another aggravated murder case, that if you wait to file death penalty until it's too late, then that just fuels speculation and misinformation. And so he wanted to get this filed quickly. So now Tyler Robinson is asking this court to disqualify our entire office. He says that there's a conflict because this 18-year-old child attended the TPUSA event. Now he's saying the entire office has to go, but it lacks merit. First of all, there is no conflict of interest. The child is not a material witness nor a victim. In fact, nearly everything the child knows about the actual homicide is hearsay anyways. And because the deputy attorney has no conflict of interest, the county attorney's office also has no conflict of interest requiring disqualification. And second, even if this deputy did have a conflict, the nature of his conflict is unlike those cases requiring screening, where a prosecutor may be privy to a defendant's communications and trial strategies, which is not happening here. So there is no risk about what happened. A public prosecutor is empowered to act on behalf of the state. Individual prosecutors have a duty. Case law, case law, case law, rules, rules, rules. And a lawyer shall not represent somebody if there's a conflict of interest. How do we determine what that conflict is? Are your actions going to be materially limited by something else that's going to draw your interest to them? How is that going to happen here? None of this impacts the case at all. He has not made the showing that having a child who was there is going to impact the prosecution of the matter. Now, he says because this kid could be called as a witness, and maybe the defense will want to call this kid as a witness, but there is a significant risk that this will materially limit his representation. He might try to protect the child from being called. He may make specific strategic decisions to avoid the child from having to testify. But the child, they say, is not a material witness. There is no relevant testimony that this person could even provide. Explaining at this point on Rule 3.7, it governs a lawyer and how they handle a case. It says you can't act as an advocate if you're also going to be a witness. And so that rule's not really applicable. And also, a witness may only testify, right? So even like say the defense wanted to call this child, they're saying he couldn't. A witness may only testify if they have personal knowledge. And the prosecution is saying the daughter doesn't have personal knowledge. Her observations are just generic. They could get it from literally thousands of other witnesses. And the text messages that they sent back and forth and the other attached affidavit explain really that she knows nothing. So she explained on the record that, first of all, she arrived at the courtyard where the event took place at 11:15 a.m. Before and after the shot, daughter looked around, saw students and other people who were there to watch the debate. Most people there were students. Some were older. And there were a lot of people there from Turning Point USA who were wearing Turning Point hats or shirts. Charlie arrived at the event between 12:05 and 12:10. Then he sat down and took questions. During Charlie's exchange with the second questioner, daughter was looking around the crowd, not even looking at Charlie, when the daughter heard a loud pop like a sound. Someone yelled, "He's been shot," in response to the only question that was posed by AC's father about the family group chat. For sure, heard the gunshot, is what she said. 2 minutes later, then, daughter texts the family that weirdly, the questioner was talking about shooting and trans shooters. So after the shot, everyone crouched down, and of course, she was scared at the time. But that's all she knew. Everything begins and ends there. As she puts in her affidavit, other than hearing the gunshot and the question being posed, no other personal knowledge. She explains, did not even really know what happened there. Had heard that someone had been shot in the crowd. After entering the building, spoke to someone. Okay, this is hearsay. Someone else said something about what they saw. So it's like the game of telephone. She can't use that in testimony, even if the defense wanted to call her. The only time that she has seen the actual shooting is when she watched social media. Otherwise, she knows nothing about it. Rehashing some of her text messages. And they say, well, we don't know with absolute certainty. Like there's even a 0.1% chance that we could call her because we have some theory. Then she might be a witness. And since she might be a witness, there is a conflict because you don't want your daughter to testify. So therefore your entire office is gone. And they say, that's not the standard. The standard has to be higher than, looser than 0%. So it's not absolute certainty. The burden rests with them, and they need to accomplish that at an evidentiary hearing to show why this daughter might be relevant and why we need her to come testify why this whole thing is a conflict. And presumably that's what we were going to argue today. But this judge is taking a long time on this, which makes me nervous. So the longer he takes, the more he's researching this to say, crap, they're right. They shouldn't be representing themselves, probably thinking that I should have ordered the AG to come out here. We'll see what he says. As explained, a witness who is unnecessary to the case is not a basis for disqualifying us. It's an irrelevant witness. Who cares? Testimony is unnecessary if it's duplicative or we could get it from other sources. And she's exactly like many other people. A bunch of people arrived on scene. Look here, Exhibit A, Exhibit C, we got Defense Exhibit E. A bunch of these other people were all there. They said that they saw Charlie Kirk walk out, start throwing hats around. All 5 of those witnesses said the shot came as Charlie Kirk to the second questioner. So if they need the daughter to come out and prove anything, they'll get it from other people. Saying accordingly, the testimony of her could provide, anything she could provide is duplicative. It's also obtainable from other sources. The other 5 witnesses actually have personal knowledge about what happened. She doesn't. And any testimony from her is already relating to uncontested facts. There's no dispute. Charlie was shot and killed at the event. The only thing that we're debating about is the shot, details about she knows nothing. She heard a shot but wasn't even looking there. And so there's no dispute that many people heard the shot. Many people dropped to the ground and ran away in panic. So in sum, any potential testimony from her is duplicative. You can go get it from thousands of other people who were there. None of what she offers is even contested. So accordingly, there is little to no risk, let alone a significant risk, that this is going to materially limit the state and bias our representation. And so because the prosecutor's daughter is not a necessary witness and her potential testimony is completely uncontested, the deputy county attorney is not limiting what he's doing. The idea that he's going to protect his child against a non-threat makes no logical sense. And so Tyler Robinson and his defense team, they lack any merit. And they're also overstating the irrational loyalty that they say dad has with daughter. In support of this claim, they say, well, there were other harrowing experiences. People are traumatized, rightfully so, after what happened. And so this is going to elicit strong emotions out of dad. Now, the state is not suggesting that the daughter didn't suffer any emotional stress. Obviously, it was pretty traumatic. We acknowledge that she acknowledges she was scared at the time, but long-term trauma is not what happened here. And unlike many others, her understanding of what happened was largely based on what others told her. And within 2 minutes after Charlie was shot, she had already run to safety, was already texting the family, I'm okay. No lasting trauma, no counseling, no therapy, no emotional problems. So dad is not overly involved in that because she's fine. Now, other than being scared at the time, there's no lasting trauma. Under these circumstances, there's no risk that something is going to cause dad to be so upset about daughter that he's going to be twisted on the case. And second, to the extent that any comparatively minor emotional impact did elicit any protective instincts of dad, that experience didn't have more impact than other experiences that were way more harrowing from other witness statements and other parts of the case that he reviewed. Like, he probably looked at the photos of the scene, right? So he's pretty much keyed off on the harshness of the case. He doesn't need his daughter to turn the screws on it. Like, he's at max capacity. So because so many others at this event suffered far greater emotional trauma than daughter did, there's no risk of this because hers is not increasing his emotional state. It's already at max. So as evidence here, yeah, there were strong emotions. And yes, we did file the death penalty, but it's not a rush to judgment. We've already done some other death penalty cases. And when there's aggravated circumstances, we learned our lesson. Last death penalty case, we filed way too late. So now we're filing it soon. Now we're filing it immediately. They did that. And while some prosecutors may choose not to file a death penalty intention, some others do. For example, we did in this case, State versus Jane, and in another case, we did it differently. So we're allowed to do it differently. It has nothing to do with the fact that a prosecutor's daughter was there. And fourth, the Utah County attorney and their decision to file the death penalty notice was a result of the lessons they learned in the other case as they cleared up for us. Now, speculation and misinformation in aggravated murder cases are extremely unsettling and hurtful to families and loved ones of murder victims. It's a good thing there's no speculation or misinformation here. The county attorney makes every effort to minimize that hardship in whatever way he can. The national and worldwide interest in this case has generated a tremendous amount of speculation and misinformation. And that has been apparent from the moment Charlie was assassinated. Now, having reviewed the evidence and concluded that the evidence and the circumstances do justify the death penalty, the county attorney determined that there was no reason to delay making that election. Filing delay would only result in further misinformation and more conspiracy theories and other things. So the county has concluded that under the circumstances of this case, delaying the filing of the death penalty notice is unnecessarily unsettling and painful to Charlie's loved ones. That's why we filed it soon. So there's nothing strange about that. That's a valid reason. And this just keeps going. First defendant's argument also fails. There is no conflict of interest. Even if he did, you can't nuke the entire county. In prior cases, they said, well, sometimes one prosecutor can go, but how do you disqualify the entire office? They run through some case law. And the court also held that because disqualifying government attorneys implicates separation of powers issue, it's generally accepted that the remedy is just to nuke the one attorney, not the entire office. But they're citing some other cases, McClellan. But that doesn't apply here. That's a crap case. And defendant also argues that because the supervisory role, that another case is being cited. And it's a whole separate matter. It doesn't implicate the same concerns. And so, in conclusion, for these reasons, the court should deny the defendant's motion to disqualify, signed by the county attorney. And then we've got the text messages, and we have the affidavit. This is the daughter. Daughter of the prosecutor says, my name is redacted. I'm 18 years old, blank. Who works at the county attorney's office is my father. Okay, so daughter and father. Now, I was present at the Utah Valley University where I am a student on September 10th when Charlie Kirk was shot. I attended a class before the Charlie Kirk event and arrived at the courtyard where the event took place at 11:15. I watched the event from the far right side of the amphitheater. I have marked my location with an X and Charlie Kirk's location with an XX. We'll take a look at that diagram in a minute on the image below. I was sitting until Charlie arrived. Then I stood up and remained standing until the shot was fired. I placed my bag at my feet against the step I was standing on and was standing above it during the event. Charlie arrived between 12:05 and 12:10. He threw out hats and sat down and took questions. While the second person in line was speaking, I was looking around the crowd when I heard a loud pop sound, like a pop. Someone yelled, "He's been shot." Everyone crouched down. After a few seconds, people started running. I ran to the doors to the northwest of where I was. I entered a building where the HF is on the image. As I was in the building, I did not really know what had happened. I had heard someone had been shot from the person in the crowd. At 12:25, I texted a family group chat, which included me, my mom, my dad, my brothers, and my sisters-in-law. Someone got shot. I'm okay. Everyone is inside. After I sent those messages, I spoke to someone in the building with me who told me that Charlie had been shot. I then texted the family group chat, Charlie got shot. Screenshots of the messages down below. I then walked through the building to the north and eventually met with a friend somewhere else on campus. My friend gave me a ride home. I did not see Charlie get shot. The last time I saw him was before I looked away, before I heard the gunshot. I did not see him get carried away or see his wound. Both before and after the shot, as I looked around, I saw students and people who were there to watch the debate. Most were students, some were older. There were a lot of people there from Turning Point USA who were wearing Turning Point hats or shirts. I did not see anyone with a gun. During the entire time I was at UVU on September 10th, I did not see anything that made me believe anyone I saw was involved in the shooting. Aside from being scared at the time, I have not had any lasting trauma from the event. I have not needed to get counseling or therapy. I did not have to miss classes or work or any other normal activities after the shooting. I have been able to continue with my normal activities without any emotional problems. The only time I have seen the actual shooting of Charlie Kirk was when I saw a post on social media that recorded it. I saw that post later that day on September 10th at my home where she went. I was not contacted by law enforcement about the shooting. And so, yeah, Charlie was down here, tucked away. Then she was up here. And then apparently she ran into the HF building, according to her. So that's it from her. And all of that notarized and signed and submitted to the court. Some other appendices. Another affidavit of Special Agent Cole Christensen. He says, I'm a special agent with Utah County Attorney's Office. And let's just confirm we're not back, right? Just making sure. We are not back at all. Are we back? Are we back live? Let's go back and check. No, this says no. Oh, we are back. Okay, so here I think we're back on Fox. Just went live.
For responding to our motion.
I just think this is
no,
ambush and another stalling tactic.
Just double checking.
To delay these proceedings.
The request the defense has made assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true.
The defense team says the adult child.
All right, so it doesn't not look like we're live. There's more from the scene. And yeah, see how they're lowered down there? So that almost looked like where the daughter was. From that angle, there are the text messages.
The prosecutor then responds, oh my gosh. The prosecutor's child says, people say he was shot in the neck and his head like tilted or something. The prosecutor responded, what the heck? And finally,
yeah, not good. All right, so that was the prosecution's filing into the court. Then the partial response came back from the defense team. And here's what they submitted. This one just came in not long ago. And in this one, they've got some redactions for us. So this was submitted on the 8th. And at this point, now they know that the prosecutors are representing themselves and that they don't have the AGs representing them. All right, so here's what they said in response to the motion we just read. They explain, all right, look, Judge, Tyler Robinson is filing a partial response saying that we're going to call witnesses at the hearing today. And the Utah County Attorney's Office is already on notice that what? That we got all our subpoenas served, right? So like they were preparing to have this hearing today against them. The UCAO, not the Utah Attorney General's Office. Now, they suggest at various points in its opposition that an evidentiary hearing on this motion may be necessary, and we agree. Other courts have noted that we need to have a hearing, and it needs to be fact-intensive. We need to have all these witnesses come in and explain exactly what went down. Let's make sure we're live over here. Pop this back out so we don't miss a thing. So the defense then continues, and they say, and will likely necessitate a hearing. And also, the Arizona Supreme Court says that all trial courts should consider all relevant evidence when making a decision on prosecutorial disqualification. This is the defense speaking. Now, while not binding on us, we're in Utah, Arizona is right next door. And their approach ensures the appropriate level of scrutiny on this question, whether the prosecution of Tyler Robinson by the relevant prosecutor, and in this case, the entire prosecutor's office, is denying him due process rights. Similarly, Nevada has also said the same thing. If you file a motion to disqualify, you might need to have an evidentiary hearing to dig into it, which is why we showed up today to do it. Now here, the Utah attorneys, they offer 14 numbered paragraphs of facts with a footnote, and they say, we'll testify. We'll come in here, we'll have the county attorney explain all this if you want. Also, they're also going to have testimony of a family member. They say that the county attorney's office posits that the burden of proving the risk rests with them. So if you're saying that we have a conflict, Tyler Robinson, you guys have to prove that and come up with some evidence. Like the burden is on you. You don't just get to make that allegation. And then all of a sudden, the whole prosecutor's office is like, well, guess that's it for us. Good call. Every defendant in the world would come in and just say, oh no, there's a conflict because of something. So you need to have, who's doing the burden of production, who's coming up with, and who's proving or at least establishing a baseline so that it goes to the other side to disprove it. Like, how is this working in Utah? We're about to find out. Moreover, the presentation of unsworn evidence does necessitate the need to develop this through testimony. And also, they're also submitting assertions of fact that are not even in their affidavits or their declarations. So the prosecutors are kind of like vouching for themselves. The 4 paragraphs pertain to the experiences of Mr. Gray, who's like writing the motion for him, and the relevant prosecutor, and some of the conclusions they have reached about the family member are their conclusions. The opposition goes on to provide significant information about the decision to file the death penalty. And again, none of that is supported by an affidavit or sworn declaration. They're all just writing it in their filing. Now, although the information appears to be provided in an attempt to distance the death decision from the disqualifying conflict, it's also lacking any specific facts about the content of the communications between the county attorney and Mr. So-and-so and about his daughter's experience, including but not limited to the timing of the communications, the nature of the communications, the number of the communications, and more. So the opposition contains additional assertions that are not supported by affidavit or sworn declaration that require further inquiry. And for example, in arguing that the experience of having this daughter present was not impactful on him, they say that he was aware of the circumstances, so his feelings for his daughter did not elicit some intense negative reaction for this guy. Now, absent from that explanation is any explanation as to how the prosecutor came to know of the circumstances in the beginning, suggesting that additional discussions were had between him and his daughter about the incident and how it impacted her. So we should be allowed to probe them in an evidentiary hearing, call the prosecutor to the stand, call the daughter to the stand, and ask them a bunch of questions. Now, the opposition also fails to offer any meaningful facts about the communications between the prosecutor and the rest of the team, other than the county attorney. So did dad go in and say, my daughter was there? Yeah, we have to get this guy, everybody. About his daughter's presence and experience at the shooting and its aftermath. And the opposition does not identify who the members of the prosecution team are at all. When communications took place, the nature of the communications fails to address the loyalty of dad and the camaraderie amongst the team. And so we need to figure this all out. These factual circumstances are necessary to be able to evaluate the impact that the conflict has had on the entire team. And finally, if we don't have an evidentiary hearing, which is hilarious because it's like, that's why we're here today to do that. If we don't have an evidentiary hearing, the defense is limited to the facts the current prosecution team unilaterally chose to disclose. And so as noted above, the county attorney has a vested interest in the outcome of this, which is where this is a good time to say, which is why they shouldn't be a part of this debate. They should have the AG come represent them. This also raises concerns about the appearance of impropriety. We heard that a lot with the Fannie cases, and although in this case, a little different than Fannieland. And the county attorney's decision to litigate this matter without an outside prosecutor. So we need an evidentiary hearing, and we need to get it so that we can get to the bottom of all this. So based on the foregoing, we respectfully request, let us develop this factual record and have a hearing on this today, which was January 16, 2026. And of course, We thought we were going to have a hearing, but now we're not. The judge is taking this matter under advisement, or is having a short recess rather, and then is hopefully coming back out soon. But all right, so that's that. Let's pause on the reading, see what else you have to say about this, see if we got any great comments we can pull up while we're doing that. Here's what the cables are looking like. We've got Fox on break, MS Now, lawmakers holding a field hearing. Yeah, they're doing a little adult field trip over there. And they got PB&J Pritzker up. As we await this judge to come back, let's check in on Pritzy.
It was completely improper, and how dare I? And even people on the Democratic side were like, well, maybe that's just a little too harsh. But as you know, that is where we are right now.
Is that where we are right now in the early days of Nazi Germany?
This president is in chapter 1 of the autocrat's playbook. There's no doubt about it.
Oh my gosh. Sorry, we had to turn that on. Are we in the early years of Nazi Germany right now? Wow, that's a hell of a question from that woman. What's her name? Cassie? Cassie Hunt? I think, is that her name? Yeah, pretty sure. All right, so my friends, let's see what you say about all of this. We're going to see if this judge comes back, and the longer this goes on, the less likely we're going to have an actual hearing. Like, we got all these witnesses there. Like, the clock is literally running out. So unless the hearing is going to go for 4 hours, we're kind of running out of time, and means we may not be having the full hearing today. All right, so let's see who's joining us, see what some of your comments look and sound like. We've got some other things that we can read, but we've read a lot of documents and we're waiting for this judge. He's like, I'm not going to tell you how long it's going to take, because he knows it's going to take a while. And he's probably trying to figure out if he's screwed up or not. We'll find out. All right, so let's see what we got cooking over here and who is joining us on the day. I see Lenny Malley. What's up, Doan? Let's see. I see NY Reno. What's going on? Says, aren't they officers of the court? Do they have to swear under oath? That's disrespectful to imply they have sworn affidavits. Oh, from NY. It's talking about the prosecutors. Yeah, like almost calling them liars. Saying it's not a part of the record. It's just their allegations. If they really were standing by the facts, they would have put it in an affidavit just like the daughter did. And we'll see what the judge does. I mean, he might just accept a proffer from them and just say, well, if you say so. Time will tell. He'll be out soon. And why this is virtue signaling by the judge. Having the camera guy put his name on the record is inappropriate. I don't know. He might be excited about that. He might be feeling like, it's kind of his day in the spotlight, time in the spotlight. What's up, Doan? Good to see you. Thank you for being here. Dan's in the house. Yeah. And I guess while we're waiting, we can poke around, see if there's anything else cooking. But the cables are pretty quiet. Let's go check over on C-SPAN, see if anything's cooking on this one. Yeah, the Democrats had this stupid field hearing. I think things have been pretty quiet. Trump just got a boulevard named after him. Get out of here.
How do I say?
What's going on over here? Yeah, the president just got a boulevard named after him. This was just moments ago. Let's see if he took any questions. Queuing this up. Here we go. Here's the reveal, it looks like.
Our country, who would think that? And that's largely because of tariffs. They don't want to pay the tariff. It's a pretty simple formula, China became powerful because of that. They don't want to pay the tariff, but it only works really here. It works best here, what a lot of people don't understand. It doesn't work in most countries, but here it works great. So because of that, we have more things happening than we've ever had, and I think you're going to see an explosion. You already see it, in all fairness, but this next year could be just an explosion of success. So once again, I want to express my gratitude to every official who contributed to this great honor, in particular Meg, who's an incredible, what a future. She's got a good future too, Daddy, right? Come on. And I want to thank especially my son, and I want to thank the great people of Florida. This is just an amazing day for me, and it's an amazing place. And we're going to have 3 more great years, but hopefully we're going to have many, many decades of greatness in this country. So we have it off to the right start. Thank you all very much. What an honor. Thank you. Thank you. Thank you very much. Good luck. Thank you, fellas. Appreciate it.
Oh, it's the reveal time. Ready?
Okay.
You've done this before.
Hey! President Donald Trump Boulevard.
That's a serious sign. Wilton, you want to come up here? Look at that. Come on. I don't know if you're going to compete with it, Wilton. This is, all of a sudden, you're looking a little bit squeezy here. Let's see. Good. Oh, that's great. Wow. I love that. Greatest president in our lifetime. Wilton, how old are you? That's not very long. And you do a great job, too. Thank you very much. Appreciate it. I'll take it. Thank you. Thank you all very much. You know, we have a wedding here now. So they said, sir, is there any way you can move it quickly? I said, I'm not moving it quickly. We're not. And the people getting married were outside, and they said, take your time, sir. This is an honor. So it's sort of cute. Have a good time. Thank you, everybody. Thank you.
All right, so they're hitting the YMCA on the way out there. All right, so Trump's got a new boulevard, which is pretty cool, I guess. So I wonder where that is. Is that in, oh, it's down there, must be in Florida. Donald Trump Boulevard. All right. He also got, I think, a Nobel Prize today. So just racking them up. Nice. All right, so still no judge. Taking a little longer than I thought. I don't know, kind of just stalling for time at this point now. Let's see what else is cracking out there. See who's joining us on the day. I don't know if there's anything else to talk about. Anyone got any questions? Hey, what's going on? Rig D. LOL, ICE agents in Minneapolis just spent 2 minutes driving in circles in a roundabout playing ice cream truck music. What is this? Why ICE protesters followed them in what has to be the funniest game of Ring Around the Rosie I've ever seen. Is that what's going on over there? They're just doing loops, confusing everybody. Rick, thanks for the dono, my man. And the great comment. All right. Well, let's see. We got anything else going on? And what else is happening out there? Trump got a Peace Prize. I think they gave him the other gals. She gave it to him in a nice little. So they didn't give it to him. He's got a Nobel Peace Prize. He didn't get it from the Nobel people. He got it from the other lady. Yeah, what's going on? Bass player. What's up, bass player? Says, this isn't California, okay? No free rides for you. What is that in relation to? Bass player. No, this is not California. No, it is not. Good to see you. Hey, there's the video, Rick D. Awesome, thank you. Good. Need something to talk about. Hey, bass player, what's up? This isn't California. No free rides for you. Oh, Judge is back. Hey, pay attention, Rob. All right, here we go.
U.S. have hearing loss.
To UVU and investigated how far away his family member was to the shooting. The family member had left a backpack. To the shooting. The family member had left a backpack when they fled. Prosecutor determined that the family member was approximately 85 feet away from Charlie Kirk when he was shot. In my view, those are the alleged facts that the court must consider to answer the first question. Does the prosecutor, by virtue of his relationship with a family member who witnessed the shooting, have a conflict of interest under Rule 1.7? And turning to that, just looking at my notes, I appreciate your patience. And so turning to defense, if I accept the facts as you have alleged in your motion as true, is there any reason to call witnesses to answer the first question before the court? And before you answer that, I understand that there are other relevant facts that pertain to the effect of the alleged conflict. Those facts would include whether the prosecutor was properly screened from the case, what conversations he had with other prosecutors, and whether the family member's experience impacted the state's decision to seek the death penalty. It is the defense position, as I understand, that those facts may need to be explored through witness testimony. But if we're just talking about the first question, whether the prosecutor has a conflict of interest under Rule 1.7, is there a need to call witnesses?
Yes, Your Honor. I understand that the court is trying to get to the threshold question that we have put before it with respect to who should be representing the Utah County Attorney's Office in this motion. But the answer to the court's question is yes, because it's not just the mere transactional event that this, that the offspring witnessed the shooting. It is the evidentiary development will get at, and again, we were only provided with an affidavit, which was very, if I may, narrowly drawn, at communications that happened after that between that offspring and their parent, between that offspring and other family members that may have been communicated to the parent, communications between the parent and other people in the office, the impact. Okay, so now I'm going to just say, if I had found out that my child was at an incident where somebody was shot and killed, I would have an incredibly strong emotional reaction, even if they were safe. Okay, so give me a second, okay? There was a horrible shooting incident at Brown University a few weeks ago. And I have a child who lives within 20 miles of there who was in Providence that day. And everybody in our family was really freaked out until we knew that they were safe. And then even when we knew they were safe, the question was, what did you see? Did it affect you? Turned out everybody's fine. But it's not just, oh, I was there. Right? And my family member didn't witness a shooting. Wasn't in a crowd with 3,000 people who all had to run and take cover.
Dude, is this guy trying to run out the clock on the day?
In case there were more shots fired. In case there were some other harm that occurred. Okay? So it's not just the fact that this person was 85 feet away from Mr. Kirk. It's that begins to that scratches the surface, if I may, of the totality of the circumstances, which we think created a conflict of interest. So the answer is yes, and that's why both the parent and the offspring are here and are under subpoena and agreed to be here and agreed to testify. Obviously, it's the court's proceeding, but nobody's moved to quash. And I think it's obvious that that's because we need further factual development. And our reply brief, if it did anything, it communicated to the court the case law, which shows that this is a fact-intensive inquiry and that affidavits are required. And here we don't have affidavits from the parent or from Mr. Gray. We have argument in a brief. But we also believe that testimony from the offspring is necessary, and they're here, and they agreed to be here. And they agreed that Ms. Visser could sign an acknowledgement of service of a subpoena. So the very, very long answer to the court's question is
it
yes,
was long. It was very long.
We need to have an evidentiary hearing.
But isn't the defense required to make the threshold showing from the facts that you're asserting? Isn't that where we begin? Not necessarily the state's response, but don't you have a responsibility to show that you've made a threshold showing of what you're asserting would rise to what you're asserting in your motion?
So the state, so the Utah County attorneys informed us that this offspring was present in a crowd.
We know this.
Was caught up in the ensuing chaos.
Does he have a stopwatch down there or something?
Heard a shot fired, had to leave their belongings behind, witnessed the trauma of other people. We can't really get beyond that without fact development. I mean, if what the court is saying, hypothetically, is I want you to go sit down and interview people, that's one thing. But if the court's saying that we somehow should have more information than the county has given us, we can't do that without evidentiary development.
It's even if you're alleging the things, if we think they're true.
We have questions about whether there were more non-recorded communications that we haven't been told about.
Then you haven't met the threshold.
I think we have a good faith, and the court could imagine
where I think the judge is
that a family would talk about such an incident, and it wouldn't just be the text messages that the court has in the exhibit. And I don't purport to say anybody should run their family the way my family operates. I'm just talking about what I think would be natural, which is families talk about these things because we want to take care of our kids, and we want to make sure they're okay. And then we need to make sure that our responsibilities to the public and to justice aren't impacted by our personal experiences. And I think that we can only get at that, Your Honor, through evidentiary development.
All right.
And that's why, and I think that the state would agree with that, because that's why they provided the court with some affidavits and some fact in the course of argument. So I think that it needs to be fully developed through the very limited number of witnesses that are present.
I understand. Let me turn to the state. What's the state's position?
So I want to make sure I'm understanding your question. The question is, there's two layers here, right? The first layer is, when an alleged conflict arises, does in this case, the county attorney's office have to conflict the handling of that allegation to another special prosecutor, attorney general's office, right? Your question is, doesn't the defense have to make an initial showing before that first conflict has or occurs that requires that delegation?
Yes.
Okay. My answer is yes. I mean, otherwise we have to have a hearing to determine if another entity has to handle the substantive issue. And then you have to have another hearing to determine if there actually is a conflict. I think there has to be at first a showing that there is, a basis for a conflict. Otherwise, someone can come in and say, I think there's a conflict without any evidence whatsoever.
Every defense
or
team and
not
defendant
evidence
would do
that's credible. I think, and for that reason, I think the court should be able to make this threshold showing based on the affidavit. Right, the affidavit and the facts that have been proffered. I think there's enough there for you to say, yes, the county attorney's office can handle this motion on its own, or no, this motion needs to go to the attorney general's office, whoever else, to handle the substantive issue of whether or not there's a conflict. I mean, I want to be clear. I don't believe under any of those circumstances that the issue needs to be conflicted out. I believe that until a conflict has been found, the county attorney's office or whatever entity has been accused of a conflict can litigate that issue without litigating that issue.
All right. In regards,
Did I make myself clear?
I appreciate that, Mr. McBride. A follow-up question in regards, they're proposing calling witnesses to make that threshold showing. What is the state's position?
No, I mean, my position is no. I think witnesses should be called one time in this case, and that should be to determine whether or not there's a conflict, not to determine whether or not the issue of whether or not there's a conflict should be conflicted.
Okay.
Even if what they're alleging is true.
I think there may have been a little bit of confusion there, and I'll take responsibility for the question. In regards to the threshold showing about the conflict,
should they present witnesses, or can they just...
So the threshold showing of a conflict of interest under Rule 1.7. So the AG's it seems to follow after in time to see if there's a conflict initially. So in regards to establishing that, defense, and I don't wish to speak for you, but my understanding is you wish to call witnesses to put that evidence on.
Then I misunderstood the court's question. I don't think we need to take testimony in order for this court to make a finding on under 1.7 that conflict-free counsel should represent the state in this motion. I am not suggesting, and I didn't mean to, that there should be 2 hearings. That's not what, so if I misunderstood the court's question, I thought the court was saying, do we even need an evidentiary hearing on your motion to disqualify? Isn't it enough for the court to just read the papers? But that was not, was that your question?
You need witnesses on the
and
threshold.
I'll take full responsibility on my question. That was really the push on it, because my understanding is that determination needs to be made based off what you told us in the beginning, that a showing of a conflict of interest, there has to be a very good possibility of a conflict, or showing of a conflict is the very first step before we go down the further road of addressing the AG's office. And so I was alluding to, based off that, does that require an evidentiary hearing from your perspective?
I don't think that it requires an evidentiary hearing, but I don't want to predict or make assumptions about the court's view. I believe that the Utah County Attorney's disclosure to us on October 20th of this situation and our assessment that it creates a conflict of interest is not frivolous. It's not taken for the purposes of delay or tactics. It's a real potential conflict. I don't know what the threshold showing is that
triggers it into a full...
permits or requires the court to exercise its authority under what is now in juxtaposition to
this guy's hard to talk
the,
into,
the Utah legislature changes its code so often, like we have to figure out all the new code numbers, but it's now section 17-68-304, which gives the court the authority to appoint the Attorney General in this situation for this purpose.
On what basis or what grounds?
17-68-304.
What is the showing
as opposed
from
to
you?
The code section cited in Jimenez. The law is the same, but the code sections have changed. But what I'm saying is, I don't want to predict or gamble with what showing this court thinks is necessary in order to appropriately exercise its discretion to make that referral. And so if the court says, I need more, then we should have an evidentiary hearing, because the important thing is to get it right, not for me to bargain on whether our papers show enough. The only thing that we know that we can show in our papers is what we were told and what we were given. And we were given some text messaging between family members and maybe some other people. I mean, the court has that, it's an exhibit. That's all we really have. And so I don't want to just say, oh yeah, there's enough there, and then have the court say, no, there isn't. Because it may be that the court wants to take some preliminary, permit us to take some preliminary testimony in order to make that decision. But what I really think, instead of starting an evidentiary hearing on a motion to determine if there should be a referral, I think that there's a sufficient showing that there should be a referral by this court because of 1.7, under the court's authority under Utah Code Section 17-68-304, before we even begin to take testimony. I mean, the fact that Mr. Gray is going to be the first witness we call already, and that the state hasn't moved to quash because it's a frivolous subpoena or it doesn't have, there's no basis in the factual predicate to examine Mr. Gray about these things, suggests that there's a problem here. That Mr. Gray's office is representing Mr. Gray while also trying to represent the state. And that's an inherent problem. And I understand it's a thorny question. It's what's the showing that's necessary, and does the court have discretion, or is the court compelled to? Is the court going to commit error if it doesn't? That's why I think that maybe some thoughtful briefing is an appropriate thing to do. Before we start an evidentiary hearing, and then realized that we got off on the wrong foot, because there should be somebody else seated at council table.
If you've reached the threshold.
2 members of the state's attorney's office who are members of the prosecution team are 2 of the 4 or 5 witnesses in this hearing.
All right.
So I'm not trying to dance around the court's question. What I'm really saying is, I don't know that we can be
Death by
stuck
boredom.
with
He's trying to win that way.
only being able to give a court a showing based on the evidence we've been given, when all we've been given is a memo that says, this person was there, we don't think it's a problem, they were 85 feet away when Mr. Kirk was killed.
And so, and I appreciate what you're saying, counsel, but what I'm trying to determine is, in your regard, in your understanding, I want to address this, the sufficiency of the showing. Is it your request for an evidentiary hearing for you to present to the court enough evidence for the court to make that determination, or something else?
If the court doesn't believe that the papers themselves sufficiently demonstrate that for purposes of the motion to disqualify, the state should be represented by somebody else, then the answer is yes, we want to have an evidentiary hearing up until the point where the court reaches that conclusion. Because
we know what he wants.
That would be the only way for us to satisfy whatever showing the court deems necessary. So I'm not going to waive an evidentiary hearing if the court's saying, well, I don't think you have enough evidence here. Obviously, the answer is yes.
You're not
what
entitled
I'm really just
to
saying
one.
is, I think that based on the papers, the court can say, yeah, this is a significant problem in a serious case that has really, really serious consequences for Mr. Robinson, for the people of the state of Utah, for the victim's family, and we should do this carefully and correctly. And I think the way to do that is to have the Attorney General of Utah designate somebody in their office to represent the county for this limited purpose until the court determines the scope of the conflict. We think the conflict requires disqualification from the case, but ultimately, obviously, that's going to be a judicial determination.
All right. Anything further from the state before the court makes its ruling on this issue?
All right.
I just want to clarify, you're talking about the need for an evidentiary hearing in order to determine whether or not the county attorney's office can handle the motion to disqualify?
No, I'm determining just an initial showing of a conflict that exists here. Like
Well, for what purpose? To disqualify the office, or to have the Attorney General's office step in and handle the disqualification motion?
To disqualify the office.
Can I take a crack at it?
Yeah.
If you wouldn't mind, Mr. Gray, just stepping to the lectern, just so the record picks you up. Sometimes these microphones are a little long.
If I could take a crack at it. Basically, I think what you're saying is kind of like a Frank's hearing, where you have to allege sufficient facts, so that based on those facts, if the court takes that as true, then you would need whether or not there would be a legal basis to conflict it out or find a conflict, right? And so if they don't make that showing, then the court can rule straightway. But if they do make that showing, if what's alleged is true, then we go to an evidentiary hearing. Is that?
Mostly, it's the initial showing of a conflict. And what happens after that will be determined, because they're bringing this up for the first time today.
Basically like a prima facie showing initially, is that what you're saying?
Essentially.
Yeah. Okay. I think that's, I'll let you.
No, I appreciate your clarification. Mr. McBride.
Nothing else.
All right. It's the court's, and I've read the briefing by all parties and listened to the argument today, and I don't believe a sufficient showing has been made for the court just relying upon the briefing itself. And
so what if she was
and so
there?
I can't make that finding based off, well, I would find that that threshold showing hasn't been met based off the briefing. And turning to Mr. Novak, based off that finding of the court, what is your position?
You haven't even made an issue up. Like, no one cares. it's not a conflict that she was there. Even if she was there and we admit it's all true, how does that impact the case? You have to show something there. They have no evidence.
Is that if the court has concluded that the briefing does not yet rise to the level of
a conflict
proof, that the court should at this time make a referral, then the court should begin to take evidence, and there may be a moment where the court says, okay, I've heard enough, now I'm ready to make a referral, and we're going to stop and
already heard enough,
pause and wait for the Attorney General to engage, and then we'll have to see where that goes, but it may be that we have to finish the evidentiary hearing. But, no,
there's not going to be a hearing.
And I think all of us can attempt to prioritize the portions of our examination so that the court can make that finding as early as possible. I'm just trying to avoid doing the hearing twice.
I understand.
Because right now, it's our view, the state is not being represented by the attorneys who should be representing it. And so if the state's going to come in later and say, well, we want to redo the evidentiary hearing,
they're not going
because the state wasn't represented by the right parties. I mean, or by the right lawyers. That's something that we would want to avoid. We want to do this once out of a courtesy to the court and to
that's just something defense attorneys say. It's kind of like a veiled
I appreciate that.
Don't want to come back and do this again, Judge.
Can this be accomplished by proffer?
I don't know what the witnesses are going to say because they've only given us very limited information. The state elected to give us information in their briefing, some of which is, like I said a few times now, is not sworn by affidavit or declaration. It's in the nature of argument. I mean, there are portions of Mr. Gray's brief, he signed it, where he makes many, many assertions of fact in the course of arguing the legal issues. And none of that is sworn. And I mean, I'm sure that
I think he's just scrambling now at this point.
And I think, so I don't think that there can be a proffer because I don't know what the proffer is. I know that I have a lot of questions about things that that the court was not told about in the briefing and the affidavits. So the answer, respectfully, is no, it can't be done by proffer.
All right. And which witnesses are you intending to call today? And I understand you're saying you wish to just put on enough and focus on the key issues, but just if I were to grant, I'm just trying to understand the scope.
Well, I think Mr. Gray is the first witness. The second witness.
We may approach.
Yes. Parties to the bench, please.
Okay.
All right. So this guy, I think, is just scrambling around right now. And when you hear a defense attorney say, we don't want to have to come back and do this again.
All right, joining me now, Fox News contributor and criminal defense attorney.
We got a criminal defense attorney right here. So what we're seeing, I think, is the defense attorney trying to basically in a veiled way threaten the judge, say, if you were wrong on this, we're going to come back on appeal and we're going to have to do this whole thing over again. Certainly don't want to do that, do you, Judge? And the smart play would be to just continue this thing, postpone it, allow us to come back. And honestly, this to me reminds me of the immunity cases that we had with President Trump. If there's a question about the prosecution or whether you are immune from prosecution, whether there's some sort of barrier that prevents it from moving forward, the prosecution can't work on the case. Remember when Trump said, I have immunity? He went into Judge Chutkan's courtroom and said, you can't continue on the case. If there's a conflict of interest, if the entire county attorney's office out of Utah might be biased or impacted by this other county attorney, they have to stop work on the case, presumably. And looks like they're coming back now. Hopefully they switch back over on Fox. Let's listen in.
This, Josh, and I had this conversation. We'll have about a minute left together. This is totally manufactured by the defense.
All right, so hang on a second. Here we go, back over. Let's go to this one. Boost this volume up.
With the county attorney's office. The prosecutor, who we believe is conflicted off, and their offspring.
Okay. All right.
See that look on his face? Ugh.
Any input from the state at this point? All right. I'm assuming the next portion that we need to address is your motion in regards to the hearing itself, the evidentiary hearing, whether it's closed or open. Correct?
Is the court looking over my shoulder at
No, I'm
media
looking
counsel?
at you.
Okay.
Sorry, there is someone behind you, but I was trying to look at you. That monitor's in the way, but I appreciate the clarification.
When the county attorneys informed us of this factual issue, and we told them that we thought that there was a disqualifying conflict, we had an agreement that we would file our motion privately, I think is the correct term,
sure,
so that certain identities were protected. And that was at the request, and we've continued to accommodate that, and we have no problem with that. So we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so. And it is, and Mr. McBride has verbalized this very well in conversations among counsel, the record is going to be very, very muddy if we can't have examinations that use names and identities. It's just going to be super, super
This judge is
awkward.
indulging a hearing on this?
And so that's why we are fine with the hearing being closed, which I think it's fair to say we view as an appropriate deference to the requests of the county attorneys.
All right. To the state.
They're going to agree.
Given the extreme publicity and the issues that surround this case, we would ask that this portion of the hearing be closed. We've had communications with counsel for
That's
the
why
media.
it should be open.
We believe that they agree to that after taking a balancing test of the public's right to know and the right to an open proceeding and the privacy interests at issue.
All right. One of my concerns that I have, and is there any other parties weighing in?
I think there may be, Your Honor, both by
Your Honor.
WebEx and here in person.
All right. Well,
Your Honor, this is Jeff Hunt. Can you hear me?
I sure can, Mr. Hunt. Thank you.
Your Honor, thank you for the accommodation and courtesy to allow us to appear remotely. With me is my colleague, David Ryman. We represent the Deseret News, KSL, KUTV, and other news media. We would like to speak briefly to the closure issue, if that's okay.
All right. I'll hear from you.
We did meet and confer with counsel for the state and counsel for the defendant concerning closure. And counsel has explained that they believe it would be impossible to conduct this hearing or even portions of it in open court
Without identifying the
without
daughter.
causing prejudice to the privacy and personal safety interests of the family member witness involved. They've told us they believe it would not be feasible or practicable to approach this on a witness-by-witness basis or an issue-by-issue basis because they believe the names of the prosecutor and the family member would be used throughout the examination of witnesses. So we have no reason to doubt the statements and representations of counsel, and in reliance on those would not be objecting to closure of the evidentiary hearing on the disqualification and the referral issues unless the court has a different view and believes that we could parse this on a witness-by-witness or an issue-by-issue basis. That said, Your Honor, we understand that counsel for the state and the defendant have agreed to review a transcript of any evidentiary hearing and make limited and appropriate redactions so that a public version of the transcript could be released. And with that, there are just a couple other brief points I'd like to make. First, we think that this should be the rare exception to conducting these proceedings in open court. There's a strong constitutional presumption of open and public court proceedings, and of course, enormous public interest in this particular case. That openness and transparency is an institutional value that serves this court, the participants, and the public well. The facts and circumstances of this particular motion, given the fact that it concerns a family relationship of the prosecutor, makes it a very extraordinary and unique situation that we feel, given the representations made, can justify the closure. Although we do believe in most cases, just the fact that a motion implicates a witness will not be grounds for closure. Second, we just wanted to get on the record that we believe that release of a transcript is not an adequate substitute for the ability of the public and the press to attend and view the proceedings themselves. For this particular evidentiary hearing, that may be the only practical mechanism for the public to obtain some information about the case. But again, we would expect this would be the exception and not become a regular practice. And finally, Your Honor, it's our position that any oral argument on the disqualification motion or the referral motion should be conducted in a public hearing. As this hearing itself has shown, a lot can be done and argued without disclosing the names of family members or the witness at issue and jeopardizing those interests. Counsel can refrain from identifying the prosecutor or family member to protect the asserted privacy interests. And we have experienced counsel. They could be mindful of that issue during oral argument, and it's not unduly burdensome for them to take those steps, and any burden would be greatly outweighed by the public interest in learning more about the motion and having at least an open argument. So we do believe that the argument, and I understand the argument will be made at a later date, not today, but that should be done in open court. That's all I have, Your Honor.
Thank you, Mr. Hunt. Anything further from the parties?
So they're going to do a hearing.
As to the oral argument, it is our request that it be closed, and the reason why is that we're not perfect.
What?
Names slip. It's happened in trials. It's happened in arguments before, and I'm concerned at the risk that could have if one of the parties, one of the attorneys, were to slip and identify those who ought to be protected. With that said, a fallback position could be not live streaming the event and requiring redaction should an inadvertent mention of a name be made.
Why do you hate us, huh?
Thank you. Counsel, one of my biggest concerns is I have to make findings of fact that are very specific. I can't redact my findings when I issue an order. And I will have to cite to the relevant facts. And quite honestly, the name of the prosecutor is a relevant fact. I can't simply glaze over that and make an assertion. It's important because it relates to various factors that you may address, and which has been brought up in briefing. And so this court is going to deny the request to close the hearing as it relates to, and I will take this motion witness by witness. I understand that there may be a witness that this is applicable to, and the court will entertain that, but because this court has to make findings and has to cite to the facts, I need to be able to do that. And since I'm going to do that anyway, which I will, I'd rather address it in an open court. And again, I will entertain any motions, witness by witness, that are going to be called and be respectful of that. But going to Mr. McBride's point, you both have that duty. It's in regards to how you present, and if you're talking about a name that needs to be protected,
don't say it.
That's on you, on how you speak. I can't. It seems inappropriate to create a safeguard to prevent you from making a mistake on accidentally saying a name. I don't believe that would be a proper reason to close the hearing just for that. And I understand the pressure, counsel. I know it's difficult, but I cannot accept that as a reason to close the entire proceedings for the evidentiary hearing portion. But again, as the witnesses are called, I will entertain the motion whether to close the hearing per witness, and we will address it as we go.
Wow. I was not expecting that. They were in agreement. They
Mr.
were
Novak.
Unanimous?
Yes, Your Honor.
With that, how would we like to proceed? Well, first, is there any clarification needed on this court's ruling as we're proceeding into the evidentiary hearing?
I can't believe we're even indulging
I just want to clarify. Are you going to entertain motions to close at the outset of every witness? Is that what I understand?
If the motion is made, yes.
Okay, thank you.
They both wanted to close it.
May we have a moment?
Yes.
This judge, so now they're going to go work it amongst themselves. Hey, are there any other better reasons to close this other than I don't want to make a mistake? Can you think of anything? They're talking about it right now. Well, maybe witness safety. Did we try that? Did you say that? I didn't say that. Maybe security concerns. Are there any crazy people in the courtroom right now trying to figure out how to close it down? This is interesting because normally if the parties are in agreement, why would the judge overrule them, right? It's okay, you guys both want this. It's supposed to be adversarial. And the government is the party that you would expect would not want to close it down because they would be acting on behalf of the public. But they don't want to make any mistakes. Loose lips sink ships. Doesn't want to accidentally out the name. But again, like, who cares about the name? She's 18 years old. She has nothing to do with the case. She should, yeah, hi, my name's Brittany. Whatever. Then we don't even have to go, back and forth on all this. I don't know anything about the case. No, I didn't say anything to my dad. Nope, dad takes a stand. No, I'm, not biased by it. Okay, end of story. All just kind of, can end very quickly. And honestly, the judge should have just nixed this from the beginning. Should have just said, okay, even if everything defense that you're alleging is true, she was there, she talked to her dad.
Oh, looks like I'm off. Would it be easier just to go into a brief recess? I don't want to make you feel rushed. You have obviously important conversations. So it's the court's intent to enter a brief recess to allow the parties sufficient time to discuss whatever you need to discuss.
No, I think I'm comfortable moving forward, making a proffer right now, and asking you to reconsider that motion. And the reason is because courts, the Supreme Court of Utah, appellate courts refer to witnesses by their initials all the time. In our pleadings, we often refer to witnesses by their initials. In Supreme Court of the United States opinions, witnesses are referred to by their initials. And that's because there's a privacy interest. In this case, I don't think a privacy interest could be greater. This case has polarized the nation in many ways. And there have been death threats made against other witnesses.
Security, witness security.
There have been death threats made. My understanding is there's been threats against counsel. Our office has received threats. Doxing is a real thing. Finding people online, harassing them online. With the technology that we have now, it's not that hard to find out just about every detail about a person through internet searches, paid subscriptions to programs that do background checks. And we are extremely concerned that we will have a person that does not need to be subject to death threats, to harassment, to doxing, to all of those things that can be avoided. We're very concerned that that will happen, and happen to this person for no other reason than this person's father is a prosecutor on the case.
Yeah, much better than we don't want to make a mistake.
I think that there's a way around this, that we can avoid those threats to her, those risks to her, and I think it's by referring to substitute names like we have in the public pleading. So, Your Honor, I would just really ask you to please reconsider your opinion. There's a stipulation from the media to shut this portion of the hearing. There's a stipulation from the defense. I think the court in its ruling can refer to the prosecutor as the prosecutor. I think it can refer to the child as adult child. I think that would be adequate. I think in a sealed record, there can be references to names. That would be my request, Your Honor. I can't ask more adamantly.
He's like, I'm going to say her name. I can't stop thinking about her. Brittany, Brittany, Brittany.
We take no issue with anything that counsel has said. That's why we completely deferred to the state attorney's, the county attorney's
Judge, don't do it. Stay
initial
strong.
request that all of the briefing, as much as possible, be under seal and then redacted.
Don't do it, Judge.
Thank you. One of the points that when I was considering this as a potential issue is that both parties filed a public version of your motions, and you used a mechanism to convey that same information. And I understand that that makes it tricky, but it was the choice of the parties to do that, to publish those public versions. And the court is fine in regards to particular witnesses referring to those terms that were used in the motions, but this court does not agree that the entirety of the evidentiary hearing needs to be closed. Wow. And it is a very broad approach to a narrow issue. And I understand and I respect the concerns made by Mr. McBride, and I understand that, and the court is willing to go witness by witness. If you feel that a particular witness that needs to be closed, the court will entertain that. I understand the issues of safety, and the court feels the urgency and the importance of that has been stated, but this court cannot find that the closure of the entirety of the evidentiary hearing is proper, given the motions that have been filed publicly online. And I have to leave it to counsel in deciding how you present the evidence, how you state the names. I'm willing to abide by the format used in those public motions, but this court denies the request to close the evidentiary hearing. And again, we'll take witness by witness a motion if that particular witness needs closure from, well,
they were basically begging
that
him.
Particular witness's examination needs to be closed.
They're both going, oh crap.
If the court's ready to begin the evidentiary hearing, we would call Jeffrey S. Gray as the first witness.
All right.
Or if the court wants to take a little break, we can do that too.
The courts can move forward. If parties need a break, I'm happy to.
No, we don't need a break.
To give a break. I know we're switching gears here.
Get to it.
Yeah, go ahead. In fact, let's go ahead and take a brief break. We need to relocate our court reporter, so this is a natural spot to take a break.
Can we have 1 moment of sidebar?
Absolutely. Hold on, counsel.
All right, so I guess we're doing the hearing, and then they're going to maybe close it for the first witness, but they'll have some argument up there right now about that, or the order of the witnesses. This is surprising. You basically had 3 people all say, close it, no problem. The judge said, sorry, I can't close it. They tried again. They went back and they said, do you have any other ideas? Witness safety. He came out and he said, we already know the witnesses. You've already published her name everywhere. So what is your problem? And now they're trying to figure out what to do next. All right, so very curious stuff. We're going to keep this open, obviously, and we'll continue to follow along and see what's happening out there. But let's see what you guys say about all of this and more. I saw a couple of great comments come in on the day. And yeah, here we had this one. Just Rhonda. Thank you, Just Rhonda, sending in 20 new membos. We had a great members only stream this morning. Shout out to our membos. What did we talk about this morning? Amazing things. Too many to even remember. Bass player. The guy isn't a lawyer. He's an activist. Where is Borowski when you need him? From bass player. I mean, that's interesting. I'm not sure who that is. Or what judge or which attorney you're talking about. The long talker. Man, that guy is so slow. The cadence of the voice. 1 word per second. And deep contemplation. Bass player, thank you for that. Hey, channel name, welcome. Says off topic, but the Epstein Files law has no recommendation for enforcement of non-release. No congressional rep, victim, or their lawyers have told us this. Basically, the law seems to be a unanimous dog and pony show to fool us. From channel name. Yeah, there's so many layers to this. We did a great interview. I thought it was good with Sean Atwood. Great questions, and we got into some good depth on the topic. But I sort of agree with that. It's like, what are we doing here? And why are they redacting all the things? Like, if you're Pam Bondi and the DOJ, why are you devoting 400? I hear the number's now 500 attorneys on the Epstein case. You just go in there, you just say, Congress wanted them. Congress can have them. Here. Just dump them all out. Good luck. They said we had 30 days to do it. And you could even go to the court. You could even go to the judge and say, hey, judge, we've got like 5 million pages of documents. We've got 30 days to release them. We would like to redact all these things, but Congress said we can't. So what do you want us to do? They said, well, you guys have to redact them. We said we don't have the resources for it. Congress didn't give us the budget for as part of this bill for 1,000 attorneys to go through 5 million pages. So as the Attorney General, I'm not going to dedicate 400, 500 of my people to go do that. I'm going to have one guy do it, who's the dumbest guy in our office, who worked on the January 6th stuff. We're going to make him go in there, and he can work on it. Otherwise, you just release everything. Say,
all right,
good
court
luck.
is back in session. Counsel?
I believe the exclusionary rule is being invoked.
Yes, Your Honor. We'd ask the court to exclude
Kick the
all
witnesses
witnesses
out.
during the testimony of other witnesses.
All right. And to the state, any input?
We agree.
Okay. And at this time, would it be convenient to just take a brief recess?
Yes, please.
All right. It's 3:20. How about we come back at 3:30 and resume on the record?
Sounds good.
All right. Court is in recess.
Oh, man, they're all so mad right now. It's great. All right, so court's in recess for 10 minutes. We got 10 minutes, and then we'll hang tight and see what else is percolating out there and see what else is cooking in. I thought that they were going to close that hearing down. Judge said no. Good for him. It's right. Let the public see what's going on in there. Don't let these two sides collude amongst themselves to close down the proceeding. So back to Epstein. Yeah, and I would say just here's all the files. Well, Rob, what about the victims? Take it up with Congress. Not my fault. They said, release it. So we released it. And I think there are some rules in there about do this or the other thing. But you say also, but they said 30 days. So, yeah, it's their fault. And then you take it away from them as a political tool. I saw Ro Khanna on with Sean Ryan. Like, this administration's protecting PDF files. It's like, I mean... Seems like they're protecting the victims so that their names are not just spread all over the internet and spread all over the place. But okay, fine. Bro, you want the files? You got them. Here you go. You can email him the whole friggin' Dropbox and he can go through them. Good luck. So channel name. Yeah. And then what are they going to do? We also covered the Maxwell stuff. And in fact, let's just pull it up because we got 10 minutes to do that. So the Maxwell stuff, the DOJ just filed a notice this afternoon. It wasn't a lot. Actually, here's another one. Looks like they filed something else. Courtesy of the docket. Yeah. All right. So here, yeah. So for example, here's what's going on with the Epstein stuff. The DOJ is providing these updates pretty regularly, every couple days or so. They're saying, hey, we're dropping a lot of materials. They're writing, all right, here, Judge Berman, Judge Engelmeyer. We know that they are over the Epstein and the Maxwell case. They say, hey, we're giving you an update. We sent you a letter last week on the 5th, and here's some more. We've made substantial progress, and we remain focused on releasing materials under the Act. And that's why we're working on compliance with the Act. But it's a lot. We have to make sure that victim information is redacted before materials are released. Now, as the department has continued with its resource-intensive efforts, it has evaluated efforts and says, we need more time. And here's some more updates. Now, the department continues to work with counsel for victims, with all the victims' lawyers, and I guess they're only victims of Epstein and Maxwell, and victims themselves to identify and redact their info. The dialogue is ongoing. There's a lot. The department is committed to protecting their info, the production of which is not called for under the Act. No, but the Act did say release it within 30 days. So you bet, are you going to follow that portion of the Act? Notably, this approach to redactions has been informed by the results of the review itself. For example, as materials have been reviewed, names that should and should not be redacted have become clearer. We're learning more because we're also getting victim input from victim counsel. So it's taking a lot of time. The department has also continued to confer with them. Specifically, we've sent them letters, and we're talking about stuff on the court docket and more. Now, to date, an overview. The department has employed look at this, this is so ridiculous, over 500 reviewers to review and redact millions of pages of material. It's like a freaking branch of the DOJ, just doc review for Epstein and the Maxwell files, and apparently nobody else. You know how much bandwidth is? Like, could we use those 500 people for, I don't know, COVID fraud or election fraud or anything else other than redacting names on documents that will be released to no avail? They're not going to release some documents with redactions that lead to indictments. We can all agree on that. So then what are we doing? It's just like redacting documents. 500 people? How long is this going to take? The Southern District of New York alone, in conjunction with the department, has dedicated significant resources, including U.S. attorneys and other personnel, which this week has been supplemented to 80 lawyers now from the criminal division, who are also coming over from the SDNY. This substantial progress is in the review. This is substantial progress. And tens of thousands of pages have also gone out to victims. And second, we're also coordinating this review with a bunch of other people. We're looking for duplication, reviewer questions, victim issues. We're processing all of this. But due to the scope of this, we're also running into inevitable glitches. Oh no, due to the sheer volume of the materials. Oh no. Glitches. Ultimately, as is clear from above, the department has made substantial progress in its review. This is a time-sensitive, intensive process due to voluminous materials. The idiosyncratic nature of many of the materials, whatever that means, the department will continue to apprise the court of its progress and let you know. But we're working hard, and we're going to do this without compromising the victim's privacy, right? And so now all the Democrats are doing is just screaming about this. Trump's getting screamed at. He's having to F off people, you know, walking around Ford construction plants now. Because they're saying he's a pedophile protector because they're not releasing the files. Well, the act also said 30 days. So if I'm AG, I would have just gone right over to a judge and just say, hey, judge, we got 30 days. We're not going to meet the deadline. What's your order? What would you like us to do? Would you like us to prioritize victim information? We have 2 attorneys here who can work on this. That's it, 2. I'll reassign them from some stupid whatever. They can come over here and do that. Oh, well, no, you need to devote all the resources of the executive branch to do this. Well, we're not going to do that. That's a separation of powers problem. If you don't like that, then you can impeach us so we can release the files, or we can put 2 attorneys on them and you'll get the files in 500 years. Which one would you like? Well, obviously not 500 years. And so as the DOJ would say, okay, fine, we're going to release them within 30 days. The act said 30 days. In fact, that's probably the better approach, to just say, oh, great, 30 days, perfect. We're going to publish everything. Drop it one friggin' giant Dropbox for the whole internet to see. Whatever's in it. I know. And you go through it and then you just put it back on Congress and blame them for it and say, perfect, now everything's out. All the victims are happy, right? All Ro Khanna is right. All happy. And then the prosecutions can really start from there. But of course, nobody wants that. For whatever reason, the DOJ is just kind of, okay, we'll just take our sweet time on it and not playing that game. But now they're getting called PDF file protectors and it's not good. All right. So still waiting for the judge to come back. We're going to have, probably 90 minutes. We'll see how long this goes when the evidentiary hearing gets underway. And let's see, we got some other comments that came in, my friends. Thank you for these. NY Renal, California. What's up, Rick D in the house? Ring around the rosy. Good to see you. Just Rhonda brought in some new membos. Hey, psychological projectionist says they could name a creek after Sleepy Joe Biden. A creek. Yeah. Yeah, that's not a bad idea. I was thinking Joe could also kind of be like if you knocked over a can of paint or something. That's how convenient he is. Anyways, I don't know. Smooth Brain Crypto. By the defense's logic, any liberal judge who has strong emotional response to any conflict must recuse themselves. Basically, and that's why to this judge, I thought this judge said that I don't think you meet the threshold. And then now we're having a full evidentiary hearing on this because apparently he thinks that you have to probe the evidence in order to make a threshold determination. So then if there is a determination of this, that there is a conflict or an appearance of a conflict, then do we have another hearing? Or after that moment, then he would appoint the state AG to come in and handle it. Well, we're about to find out. Rick D, what's going on? Shared this link over from Nick Sorter. Let's cue this one up. Shout out to Nick. He's boots on the ground, man, over there getting after it. says ICE agents in Minneapolis just spent 2 whole minutes driving in circles in a roundabout, forcing leftist activists to follow them while blasting ice cream truck music through their loudspeakers. So they have like a little caravan going on. Ford Fisher. Just doing loop-de-loos over there. All right, nice. Man, shout out to our federal agents out there cleaning up the streets. Smooth Brain Crypto. 100% the defense tries to call the daughter as a witness at some point, no matter what. Total clown show. Yeah, and again, even if everything that they said is true, like daughter was traumatized, daughter talked to dad, dad responded, all of that, is that a conflict? Like, what's the consequence of that? They're saying the death penalty is really, I think, the only legal consequence. They're saying that the death penalty invocation and notice was a result of a conversation between Jeff Gray. Like, I think that's the legal consequence that we've heard, but I haven't heard any others. And they have a perfectly plausible explanation. And what evidence did they have that there's a causal nexus between that decision and Jeff Gray? I guess they're going to ask about that right now in the evidentiary hearing. It's such a stretch. I can't even believe we're wasting our time with it. I don't think the judge is going to disqualify them ultimately, but he is indulging in this, and that's to his detriment. So a good decision today from the judge to open up the hearing, keep it open, and also kind of a ridiculous decision for even indulging it, but we'll see. This old guy, OMG, this guy and Hakeem Jeffries attended the same public speaking classes, except this guy missed the hand gesture class, Hands 101. And Hakeem does the triads, right? He speaks in threes, like that attorney from Seinfeld. Maybe that's where he got it from. This old guy, wow, I thought we just wasted 2 hours, but no, we got a hearing coming up soon. We're in for it. Surprise, surprise. Good to see you, this old guy. Yeah, it's been a little bit of a roller coaster today. Spice Ship. Would it be worth it to bring a class action lawsuit against Minneapolis and Minnesota for directing local and state law enforcement to not assist in keeping the peace at federal law enforcement activities? It's a great question, Spice Ship. And the question is, can you sue bad elected leaders for being bad elected leaders? The answer is really no. You can't. They call it a political question. It's kind of a standing issue, or it's a justiciability issue. They would say that your remedy is to vote. Don't get a class action and sue. Just go rally some people, run for office, vote out the bad actors. But the courts are not the appropriate forum for that. So you can't just sue, otherwise we just sue all of our leaders for being so terrible. Can't do that. They say, sorry, your case is not valid. It's a political question. Go vote differently. But maybe it would be nice if we could. Hey, Sean, formerly artist called John Cuxack, says, that's an American flag, not a Soviet flag, counselor. Those were the words a workers' compensation referee once told me years ago about open court's importance. Somebody was saying we should close the court, and he said, this is not Soviet Russia. This is America. Yeah, here, Jarbot. Good comment on that, Sean, formerly artist known as John Cusack. Hey, Jarbot, why does the DA want closed hearings? Any witness could face threats, not just his family, unless he's admitting that's the real conflict, which the defense would be creating anyway. Well, we've seen a lot of this, Jarbot. I mean, they wanted to close a lot of this down from the very beginning. We were critical about this from the very beginning. Why is the prosecutor agreeing to have Zoom hearings and virtual hearings with the cameras off on all this stuff? It's because I think they're nervous. You just heard it from him. It is a big case. I get it. But Your Honor, we make mistakes and it's high pressure. Yes, it is high pressure. That's why you're a prosecutor at the highest level of your state. It's a very important, very powerful position. Doesn't mean that the public has to suffer because you're afraid you're going to make a boo-boo. Judge didn't buy it. Lady Desiree music in the house. Lady Desiree, thanks for bringing your friends over here. Lady Desiree, shout out her friends. Welcome over. Thanks for joining our stream. They're late. They're supposed to be back in session at 10 minutes, and they're not. So I don't know what's going on over there. They better not have closed this thing down or anything. Your boy will not be happy about that. So we're going to keep our eyes on that. Continue to pay attention over here. Meanwhile, we got some tension, it looks like, Bagel Boy, what's up, Bagel Boy? Man, bagels are great. Bagel Boy, thanks for joining up. Monthly supporter over on the Rumbles. You rock. Great to have you over there. Yeah, and here's what I was talking about earlier about Trump getting the Nobel Prize.
% of them I didn't deserve.
80?
90% of them I didn't deserve. Yet
and
I still display them proudly in my many offices and libraries. And people that don't know me and what a shyster I am think they actually deserve them. And that's what I want to project. I'm not saying this is the way Trump sees things, but if you go to all of his clubs, it's the same thing. Every wall, every niche, is that how you say it? It houses some sort of award or plaque, silver cup, and most of them he deserves. Yeah. Now, if
like
he
when
gets,
he won men's singles at the U.S. Open a few years ago.
He actually is a good golfer, very good. Now, when he does get the second one, he'll get another one. So at some point, yeah, I do.
He needs bookends.
He needs two. So do you give the one back if you get another Nobel? I think he keeps both, and no one else has ever won 2 Nobels. And really, I would do the same thing.
Should he have kept the award that he was given by the opposition leader in Venezuela?
Would you ever reject an adopted child?
Well,
This is just an adopted child, this Nobel Prize. She didn't want it, and he's taking it, and he's going to treat it like it was his own.
Under his wing. What a nice guy Trump is. All right, we got some other comments that just came in. Mrs. T. Rush, what's up? We have to be careful we don't damn someone until they have been convicted. We complain when they do it to us. We need to be better. From Mrs. T. Rush. Well, certainly we support the presumption of innocence and due process. And when it comes to this Tyler Robinson case, a lot of people have very strong opinions on it. We're, of course, trying to cover the case based on the filings and the proceedings and the facts that are in front of us without speculating too much. Because it is a curious case. Yeah, there's a lot of things that I think we're going to learn as it develops. But Mrs. T. Rush, we do have a presumption of innocence. We do have due process. And so today, I don't know that we were condemning anybody today. Maybe I was, probably was. But we're commenting on the proceeding. So hopefully that's coming across. Rick D. Silly Rob, you silly goose. You better than anyone know that 10 minutes in court really means 20 to 30 minutes. Yeah, it usually does. This is turning into at least a 20-minuter. Supposed to be a 10-minuter. Coming up on 20 minutes. And honestly, I feel like they're trying to burn the clock out. Like nobody wants to have a hearing. It's Friday. They're like, it's MLK Day. Everyone wants to go home and have pizza. So like, okay. Is he still in the toilet? All right, great. Perfect. Everyone's still in the toilet right now. We're going to come back. We're going to have an hour left of court. Unless they want to go over, court time, but nobody in court on Friday wants to go past 4:30. It's almost 4 o'clock our time. All right, so we'll keep our eye on that, see what else is happening. We got some footage outside Minneapolis, also on CNN.
And disabled and still being treated the way she is. What happened there? Is your office collecting information about this incident?
Yes, as a matter of fact, we opened up a portal so that we can collect information. If you go to our website, which is ag.state.mn.us, and share these incidents with us. We're collecting them right now. This video that you're showing was very painful to watch. It didn't seem necessary at all, like so many things. I mean,
She is resisting and obstructing all of their commands. Do you think that they should just sit there and allow instigators and agitators to prevent them from executing the law and from doing their jobs? Yes, they do. Because if they can stop them from actually removing people, that's a win for them because that's their constituency, of course. All right, so that's over there. Been a very, very long 10 minutes. Now it's 20 minutes, and we're seeing if they're coming back. It's been a wild hearing today. Not what we were expecting at all. But we're here for it. All right, let's see what's going on over here. Let's go back to Fox while we wait.
She had it
Never say
framed.
no to a
Gift
chick.
horse in the mouth. He had it framed.
The same way you bring ice cream to children when you want them to be on your side, you have to bring the prizes to the president. I just think, again, let me just finish.
That's Joe Biden's prize.
I get 20 seconds here. Let me just say, the president I don't normally look at polls, and I think polls are irrelevant until you get 3 months out from an election, but they are instructive in ways. A majority of the country believes that the president's not focusing on their priorities. Venezuela, Minnesota, Iran, and Greenland, as important as they are not what's on voters' minds. And for this woman who won an election and they stole from her, President Biden agreed with that, President Trump agreed with that twice, for her to fear for her life and to have to leave the country. She won the Nobel Peace Prize. We did the right thing taking Maduro out. And for her to have to come to the White House, didn't get a picture with the president, didn't get a press conference with the president, didn't get anything official, yet she gave him her Nobel Peace Prize, which she put her life on the line. I'm a fan of the president, but I just think this is wrong. The president should give her her Nobel Peace Prize back and win his on his own.
What about the angel families that the president is working on behalf of to get those ICE agents out? I mean, I think when you say Minnesota and things like that, the president's working every day for the values of American people and voters. It's just not the sexy issues.
5.6 GDP.
And we will discuss all of that during the commercial break. The fastest is up next. Stay with us.
All right, so we got no feeds that are showing any of the Tyler Robinson stuff. I was wondering if the pools maybe split up or something, but still nothing over there. Oh, we've got that one former senator, right? I think that's Claire McCaskill or somebody. Sheesh. All right, so let's see what else we've got percolating out there. What else do you guys want to get into while we're waiting for this judge's 10 minutes to expire? Let's take a look at silver prices. Someone suggested silver prices. Great idea. La Raza. Wow. All right. We got some ups and downs over the day. Silver down 2.6% on the day for our silver holders. Oh, man. Making its way back. A little bit of a rebound here, 459 on those markets. Silver futures. What about top stories as it relates to silver? And yeah, these numbers have been wild. Silver price is falling as Trump will not impose critical mineral tariffs for now. Silver prices up more than 200% in the past year. A lot of people are talking about copper too, saying the copper is going to be the real deal. And you know, this is starting to feel like a little bit of a closed hearing. I thought he said it wasn't going to be closed. What's going on over there? All right, so what else we want to talk about? Hey, what's up? Crisis over at the border. Trump's new boulevard is the old Southern Boulevard, part of which runs through very bad areas. Love ya. Well, not for long. Once people realize they're living on Donald Trump Boulevard, they're going to get their lives together. They're going to say, I am capable of so much more. And then they're going to go get a fresh coat of paint for their house and cut their grass. And it's going to be a great area very soon. All right, so those are the silver futures. What else do we want to look at? Let's see what else we got cooking. Let's see if there's any stories on, see if anything's going on C-SPAN right now. Fox is at commercial. They all cut to commercial at the same time, as you can see, so that you can't change channels. See, they all go to commercial right here. All at the same time. You got pharma, and pharma. Wow, 4 pharmas. Look at that, right back to back. It's incredible, isn't it? 4 pharmas all across the board. Air Supra, Immuno 150, Rinvova, and someone else. It's just perfect. All right, let's see what else. This judge, now I'm starting to worry that we're not going to have a full hearing today. Democrats held a news conference. Still pharma time on the cables. Let's see if there's anything else new. It's percolating. Let's check the dockets. All right. When in doubt, let's go check the dockets. What else happened today on the court dockets? Can't even type. All right. We're pulling it up. We've got some new updates. We already talked Maxwell. Now we've got Ryan Ruth. We got an update on Ryan Ruth. That was the Trump assassin. Remember him in Florida. He filed something today. These are wild filings. Motion to seal. Okay, that one looks pretty normal. He asks that we seal the request for a downward departure. And see if he submitted anything else. Oh, we got a sentencing memo. that got dropped from the prosecutors today on this. This is curious. 21 pages. They're saying he should be sentenced for how long? His arguments for a downward variance are completely meritless, wholly meritless. All right, this could be interesting. This is the Trump assassin, the guy who was traveling back and forth to Ukraine, apparently, before he was hanging out on the golf course trying to take out the president. On September 23rd, after a 2.5-week trial, a jury convicted Ruth 5 crimes related to his scheme to eliminate the president. He plotted painstakingly to kill President Trump and took significant steps towards making that happen. When he was there at the Trump International Golf Club, he got a military-grade SKS rifle and put a round in the chamber, pointed it towards Trump and his protective detail. Ruth was only thwarted in his assassination attempt by a Secret Service agent who found him, fired his direction. Jury came out, convicted him all 5 counts. He was represented by counsel most of the time, but then represented himself, fired his attorneys, and said, I can handle this. With and without counsel, Ruth made calculated attempts to make a mockery of this proceeding. Moments after publication of the verdict, with some jurors in the room, then Ryan Ruth tried to off himself. He grabbed a pen and tried to jab it into his neck, puncturing his jugular. Now, this court subsequently appointed counsel. They're like, all right, this dude's crazy. And this is what we're talking, like, you know, the dude's obviously like nuts, but he's not that nuts that he can't represent himself at trial, right? So we have that. Then the court subsequently appointed counsel to represent Ruth at another sentencing. The court order came after Ruth advised in a pro se letter. He said, I hate our dictator missed the trial. Can my appeal be heard in 30 years when he is gone? Perhaps now that I'm found guilty, it might make it easier to trade my life for another. He was saying, I'll die if you want to do something else. Guy's lost it. So cravenly, in cold blood, he tried to kill Trump. And the pretrial services, the pre-sentence investigator offense conduct section, lays out in detail the evidence that was presented. Charges were linked to his plan to kill the president. Happened on a golf course. He wrote a whole letter about it. Flew from Hawaii, went to North Carolina, got a military-grade SKS rifle. Then went back to Palm Beach, camped out at a truck stop, researched where the president was going to go, followed his patterns, and then waited out at the golf course to try to take him out when he emerged. On September 15th, he set up a sniper hide in the pre-dawn hours, waiting for Trump to turn the corner, playing golf on that day. He parked his car, now bearing a stolen Florida tag, across the street, was discovered. He fled the scene, abandoned the rifle, wanted to escape undetected, but we proved at trial he was targeting Trump. And he also was putting others at risk of death. He moved the rifle in the direction. They made eye contact. He used Russian-made ammunition that risked over-penetration. He could have hit additional people nearby. So the whole thing was reckless. And so we are recommending life imprisonment. Life imprisonment is the guideline. And we agree. And so does Ruth. He even posted in another file. He said the defendant is in the sentencing range of life. There's no dispute that the guidelines say life. So we reached the recommendation. He's at level 33. We think we should add 6 levels to that because of a terrorism enhancement and other conduct. And the enhancement adds 12 levels to Ruth's offense and puts him automatically in a criminal history category of 6 instead of 1. So you need to examine all these things. Guidelines, history, characteristics, so on and so forth. And so he filed an objection to the PSR, but he didn't refute it in any real way. And so we say you should follow the guidelines in prison for life. We've got various factors. He planned to assassinate the president for a long time. He had many options. He had a rocket-propelled grenade he was looking at, 50 caliber weapons, attempted to assassinate him. And so you get the story. He's got a lot of, oh, here we go. We're back. All right. So we're back in session.
The first clip
on Mr. Robinson's lips as he is trying to communicate with me sitting next to him.
Thank you.
If I may reapproach with the second video, Your Honor.
So we definitely missed something.
This one is 5 seconds, Your Honor.
It looks like, okay.
And Your Honor, the second video is a clip from a court TV posting showing Mr. Robinson's lips moving as he's attempting to speak to Ms. Nestler. And Your Honor, one last thing I'd like to add if I could, which is I think the court very correctly and very cautiously admonished the cameraman about your December 23rd order before this hearing began. And he said he understood the order, and I think the order is very clear as to this lip reader provision. And I can elaborate further why it's damaging, but I think it's obvious to the court if the media is allowed to interpret the conversations between counsel and his lawyer, it creates all sorts of problems in terms of Mr. Robinson's right to a fair trial.
Thank you, Mr. Burt.
Thank you.
And just one more question. I apologize. Just for the benefit of the record, from your position, citing to the standing decorum order, the violation itself, so we can connect it all from your arguments.
Yes, Your Honor. I forget the paragraph, but there is a paragraph in the court's latest December 23rd decorum order.
It's paragraph 48.
48. And it's been a feature of every decorum order. I think we're on the third one. But from the start, the court has prohibited zoom-ins to allow lip readers to interpret what's being said between counsel and the defendant.
And finally, I think you led with this in regards to the sanctions being requested. You cited to the court sanctions, and then there was a second one referring to, and I want to make sure I wrote it down right, because something along the lines of not showing Mr. Robinson at all. I want to make sure I understood that request.
Sure. The request was either to exclude the cameras for purposes of this hearing in its entirety because of the violation and because we can't be assured that the cameraman's going to comply with the court's order. The second request is if the court is not going to exclude the cameras, then it should, at the very least, order the cameraman not to shoot any footage of Mr. Robinson. That the camera should be focused on the court and the witnesses if the court permits that, but it should not be zooming in on Mr. Robinson. His demeanor, his conversations with his lawyers have nothing to do with the newsworthiness of this case. And what it's allowing is very prejudicial information to be leaked to the public through these lip readers and body language interpreters, and it's creating massive prejudicial publicity for us.
What do you say, lip readers?
So that's the request.
Thank you, Mr. Burt.
Thank you.
I'll hear from other parties if they wish to be heard.
Yes, Your Honor. Michael Judd on behalf of the media entities. I want to take the court back to that specific paragraph of the decorum order because I do want to make sure we're on the same page about this. It's the second sentence of paragraph 48 of the decorum order that I understand is at issue here. It does say no visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel, at counsel tables, or bench conferences with the judge. The zoom-in language that you have heard referred to previously doesn't fall in that sentence. The zoom-in language comes in the next sentence, which says no one may zoom in on anything on counsel's table or the bench to identify any writings. So those are two separate things. The first that we learned about this was during the break. I briefly reviewed the two videos that the court has reviewed. I understand that those were 9 seconds and 5 seconds long. I identified the provision of the decorum order that I believe applied here, spoke to the pool cameraman about that, ensured that the rule about capturing conversations involving counsel at counsel's table or at the bench so that they may be decipherable by lip readers was an important provision in the court's decorum order, that it should be followed. I understand that the cameraman understands that rule, that any capture of those conversations was inadvertent. I understand the concerns raised by defense in this case about potential prejudicial effect of something that is intended to capture conversations. I don't believe that that's what occurred in this case. I believe that the court's order should be understood and applied as written and done so strictly. But I don't believe that there's been a violation here. We've been now on the record for 3 hours. I believe that the total length of the two videos that were shown to the court were 14 seconds long. Whether or not either of those conversations rises to the level of capturing the movement of somebody's lips so that it can be decipherable from a lip reader, I'm not in a position to judge. But I can assure the court that the media is aware of that provision of defense's concern about the potential violation of that order, and that they will take that seriously. That's already been raised, already been discussed. As far as the remedy sought here, I think that excluding all cameras from the courtroom for this important part of this important proceeding would be broader than any sort of remedy would be necessary here, as would the direction that the cameras not show Mr. Robinson in any way. I understand that potentially any shot on a still camera, on a video camera, of a defendant in a criminal case could potentially be twisted or used by some to try to impute some sort of thought or some sort of idea. But I don't believe there's anything in the court's rules. I don't believe there's anything in the ruling so far to date that suggests that the way to address that kind of concern is to say that a defendant, a critical figure in a case like this, and one that the decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about the decorum order and what it requires. We recognize the importance of doing it and that there can be consequences if that's not kept. The media understands and hears that, and do not believe that any further reprimand or any sort of further exclusion is necessary here.
Thank you. Well, before I turn to you, I want to turn to the stage. I want to give all parties an opportunity, and then that allows you to respond to whatever they say.
Your Honor, we have nothing to add. We'll submit the issue.
All right, Mr. Burt.
Judge, the problem with that explanation, that's the same thing they said last time on December 11th. And on December 11th, there was a same violation. Lip reader. I can pull up for the court what the electronic media did with the prior violation. They hired a lip reader. The lip reader purported to derive a confession from the incident, and they posted that. It's still up there. So it's great that they apologize, but once this kind of damage is done, it is irreparable. And we can't continuously have violations where the media gets up and does this mea culpa, and they just continue to do the same thing. And I point out to the court, this is the same pattern that happened in the Kohlberger case that's discussed in the motion we filed today. And eventually the court there had to order that all coverage of Mr. Kohlberger's face was prohibited. And we attached that order to the motion that was just filed with the court. And I understand the media's desire for dramatic coverage. I understand how they want to incriminate Mr. Robinson. But that process is supposed to happen in a trial, not in the media. And it's a serious violation. It's one that the court should not just blink away and say, I accept the apology, especially after the court was so clear this morning. Calling the cameraman up, asking if he had read the December 23rd order, and his response was, I'm good to go. Meaning he had read it, and presumably he read that provision about zooming in on lips. There's no excuse for it. The court should take some action.
Thank you, Mr.
Thank you.
Anything further from any of the parties before this court makes a ruling on this issue that's before it?
No.
I just want to make one note, Your Honor. Those clips that I showed you are just small portions of much longer footage that was available in the live stream. That was just what we needed to compartmentalize to get it to Your Honor, but it was a much more extensive period of time.
All right. All right, I appreciate this being brought promptly to the court's attention. This is an important issue, and the court takes it very seriously. As it relates to today, well, first, I did put on the record
at the very
very
beginning
clearly that there would be potential consequences for any violation of the court's December 23rd, 2025 standing decorum order. For the first part, well, and I've also had a chance to view the two clips that was presented. It was shown to all parties. The first appeared to show an attorney and Mr. Robinson speaking for about 9 seconds is what my memory tells me, reminds me. The second clip was for about 5 seconds. I believe it was from a slightly different angle, but it also captured that. And in both instances, I could see Mr. Robinson's lips moving. And I don't remember about the second clip, but I believe in the first clip it also showed counsel's lips moving. But notwithstanding, that was in place. I also refer to the statement made by the counsel for the news media, and going to, it is paragraph 48, and I will read it in its entirety. No audio recording is permitted of the conference involving counsel at counsel's tables or during bench conferences with the judge. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel at counsel's table or bench conferences with the judge. No one may zoom in on anything on counsel's tables or the bench to identify any writings. Now, in regards to the zooming, I know a representation, and it's easy to, as you're reading, to kind of combine it, but I'm not finding that zooming in relates to the lip reader portion, but that's not material. I do find that, and I'm not a lip reader, so I don't know what the standard is for lip reading, but I do note that 9 seconds in that first clip, one could see his lips moving, and it is a significant time for, as it relates to this particular issue. It wasn't a passing shot. It was focused on these two persons, and so I find that the decorum order, as it relates to paragraph 48, as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader, I find that that has been violated. In regards to the second clip, 5 seconds, where it shows Mr. Robinson and I believe one of counsel, that I was able to view Mr. Robinson's lips moving. It wasn't a passing shot that it just so happened to capture. It was focused on them. I find that that is a violation of paragraph 48 as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader.
Just get a different
to the next section, finding that the violations have been shown as the court has reviewed the purported evidence of these two violations, I turn to the sanctions. Previously, I stated that under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both.
Not the camera guy.
I find that applying this sanction would be disproportionate to what the conduct was in those two clips. And the court notes that it is the court's discretion on whether to apply it or not. I find that the court will not issue this sanction. In addition, the other sanctions the court stated earlier today, in addition, the court may impose the following remedial measures if warranted. Immediate suspension of video transmission of the hearing, with proceedings continue only on an audio-only basis for this proceeding where the violation occurred, and disqualification if necessary and narrowly tailored, of the news organization that filed the request in order for the electronic media coverage of the court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter where the court determines such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. The court also stated that before making a decision, it would allow counsel to make argument or statements, in which the court has done, and that the court's actions are not intended to have a chilling effect on the open and transparent courts or on responsible news gathering, and that the court is fully committed to the presumption of open proceedings under the applicable rules. That being stated, and as the court was listening, Mr. Burt has suggested that one of the potential sanctions is that for the camera for the remainder of the hearing, and not to show Mr. Robinson at all as a sanction for the remainder of today's hearing, and so the court considered that as well. This court does not wish to make a disproportionate decision on the actions, and it does note and does not minimize the violation. Therefore, this court will take up the suggestion by Mr. Burt that during the remainder of this hearing, that the camera shall not photograph Mr. Robinson at all, and that will be the sanction of this court. I will allow the pool camera operator to reposition the camera to adhere to that. Well, first,
I think it's already done.
Sir, I'm going to ask you to come forward because I want to make sure that's even a possibility. And again, I don't mean to put you on the spot. I'm simply, I don't want to set anyone up for failure. I don't want to make an order, and if it's not possible, then further sanctions could apply. And I recognize that it wasn't your anticipation to be on your own camera, but as it relates to not showing shots of Mr. Robinson for the remainder of this hearing, what are your thoughts?
I can do that. From where I'm positioned now, I can shoot this lectern, I can shoot the bench, and I can avoid the attorney tables altogether if that is what is desired.
All right. Do you need to do any repositioning of the camera to accomplish that? And I'm willing to give you that time to accommodate that. I just, again, I don't want to set you up for failure given what's happened. And so what are your thoughts?
No, I think the position I'm in, I am okay to avoid the attorney tables at this point and just shoot, this forward part of the courtroom.
All right. Thank you.
Thank you, sir.
All right. Turning to the parties, any clarification needed about the order of this court and the sanction that is imposed?
It happens to the best of us.
Your Honor, I only have one. It sounds like this issue is specific to video coverage and that the order not to take any imagery of Mr. Robinson would not apply, for example, to the still photographers. Do I have that correct?
Well, I'll hear from the parties before I offer that clarification. Do you wish to weigh in on that issue?
Oh. Pictures now.
Just to indicate to the court that one of the problems is not just with the audio, with the video coverage, but most of the coverage is not covering the proceedings so much as close-ups of Mr. Robinson and comments about his demeanor. So if they catch him in a moment speaking civilly to his attorneys and he happens to smile, that then is twisted into evidence that he's some sort of a remorseless killer. So that applies to the still photography as much as what's going on with the video. So we'd ask the court not to permit still photography, at least for purposes of today. And I think after the court sees the motion, we'd be in a position to talk about the future. But I think for now, that's our request.
Thank you, Mr. Burt.
Thank you.
To the state.
Nothing further, Your Honor.
And any other inputs? All right. This court narrowly tailors its decision as to the violation, and the violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is in this moment, it is eluding me, but the person who's operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with the 9-second clip and the 5-second clip doesn't apply to them. And so I'm going to limit the sanction as it relates to the pull camera photographer, again recognizing that the standing decorum order applies equally to the still camera photographer. Thank you, counsel. I appreciate you bringing this to the court's attention and the seriousness and professionalism that you presented this to the court. So thank you to all parties. And again, to the camera operator, do you need time to test out to ensure that there is
doesn't.
Any inadvertent capturing? I'm willing to do that. I just want to make it clear as day that Mr. Robinson is not to be captured in a sweeping shot in any form for the remainder of this hearing. All right. All right, counsel.
3 hours later.
With that in mind, how would you like to proceed?
Where is he? Oh. We'd ask the court to, and the clerk to swear in Mr. Gray.
Mr. Gray, if you would approach and stand before the court clerk to be sworn in.
Finally, good Lord.
You do solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can sit down there.
Mr. Gray, if you'd like, have a seat. Usually we have water bottles. If not, there's one right here.
No water. Get to the point.
All right.
No time for drinking. We've got 50 minutes left of the day. They may go late.
Mr. Gray, I'm sure you've heard this before, but if you could position the microphones close to you, just to ensure that the record picks up your testimony today. Thank you. Mr. Novak.
May I proceed?
Yes.
Thank you, Your Honor. Mr. Gray, how long have you been associated with the Utah County State Attorney's Office?
3 years.
Okay, and was it 3 years ago that you were elected to be the chief prosecutor of that office?
Yes.
All right. And had you ever previously been associated with the Utah County Prosecutor's Office in any other capacity?
I've defended on criminal appeals. I was a criminal appeals attorney for the state of Utah for 23 years. So I represented the state of Utah on those criminal appeals, which would include Utah County.
Okay. And did you ever have any professional relationship with the Utah County Attorney's Office in any other capacity other than the appellate work you did before you were elected?
Not to my recollection, no.
Okay. Because we're in an open session and based on some of the guidance from the court, I'm going to ask you questions. Well, let me back up. How many prosecutors are in your office right now?
Well, that are with our courts, that are actively engaged in our court system is 30, and then we have screening prosecutors as well, and that would be another 7 or 8.
Okay, so I'm going to try to...
I should stop because I also, my executive team, they don't have courts, so there's another 5 of them as well.
Okay, so let me ask a better question. How many prosecutors in your office represent the state in felony matters?
Well, all of them that I just described.
30?
I mean, even the screeners. Yes, the screeners, my executive team, they are assigned to special cases. Usually my executive team, for example, aggravated murder cases, some homicide cases. So they also are prosecuting and represent the state in trials.
Can you explain what you mean by the executive team?
The executive team would include, obviously, myself. I have 2 chief deputies, one chief deputy, another chief deputy's general counsel, and then I have a division chief over major crimes and a division chief over general crimes.
So is it fair to say that there are at least 24 prosecutors in your office who have substantial experience prosecuting serious offenses?
24? I don't know that I'd go as far as 24.
Okay.
Certainly all my SVU attorneys have that experience. Most of my violent felony attorneys have that experience too, but not all.
Okay. And do you know how many attorneys in your office have actually participated in homicide litigation?
I don't know the exact number, but I would say maybe 15.
Okay.
But I guess I should clarify, not all of them have the experience in aggravated murder cases, and that's why we specially assign those attorneys.
Understood. And how many do you believe have experience in aggravated homicide cases?
Probably 7 or 8.
And are all 7 or 8 assigned to this case?
No.
This is the slowest hearing we've ever heard from, ever in our life.
Are the
what is
5
going
other
on
than
over
you
there?
who are assigned to this case experienced in aggravated felony cases?
4, well, either 3 or 4.
Of the 5?
Yeah.
Careful, camera guy. Careful.
All right, now I'm going to ask you some questions about a specific member of your office. And because the court may or may not ultimately order that attorney's identity remain sealed. You know what I mean by the word sealed, right?
Yes.
I'm going to refer to that person as Prosecutor A, okay?
Great.
You up with that?
Sure.
Yeah, he's fine with it. He's a county attorney. Don't talk to him like
So
a
how long have
child.
you
Let's
known
go.
Prosecutor A?
About 3 years.
Gosh.
In your work as appellate counsel for the state, did you have any contact with Prosecutor A?
I may have. I don't recall. We generally send something out to, when we get an appeal, we generally send, the AG's office, we send something out to the prosecutor, ask them to fill out anything that we should know. More often than not, they never send us anything. And because it's an appeal, I mean, we're bound by the record. So there's not usually an occasion, but sometimes there is. But I couldn't say for sure that I've never talked. I certainly don't remember ever talking to him, though I could have.
Okay. Is Prosecutor A a member of your executive team?
Yes.
Okay. And did you select Prosecutor A to be a member of your executive team?
Yes.
And that was at the beginning of your
Yes.
tenure as the Utah County Attorney?
Yes.
All right. And so you've had close working contact with Prosecutor A, who's a member of your executive team for the past 3 years?
Yes.
All right. And that, unless you're out of the office traveling or on vacation, that's basically every work day of the month, correct?
Yes.
All right. And have you met members of Prosecutor A's family? Ever? Let's just start with ever.
What's that?
Ever. Have you ever met members of Prosecutor A's family?
I have met his wife.
Okay.
I don't know if I've met his kids. I may have in passing, but I don't really. If I did, it was like at a function, they say, "This is my family," and introduce me. But I don't remember.
Have you socialized with Prosecutor A and his wife?
I think we went out to dinner once after a conference in St. George with some other prosecutors and their wives.
Okay. Have you ever been to Prosecutor A's home?
No.
Has Prosecutor A ever been to your home?
No.
It's not Fannie Willis here, all
You
right?
engage in recreational activities in any way with Prosecutor A?
No.
Whatever you do, running, pickleball?
No. I need to do more running, but unfortunately I don't.
All right, understood. Okay, now, Prosecutor A has an adult child who was at the September 10th rally at Utah Valley University, correct?
That is what I mean, I don't have personal knowledge of that other than what they have told me. So like, I never saw that adult child, but I'm assuming, yes, that's true.
Okay, but on September 10th, 2025, at the moment that Mr. Kirk was shot and ultimately died from that shooting at Utah Valley University, you were in Davis County, right?
Yes, I indicated in the motion that it was Ogden, but it was actually Layton. So it was Layton.
Layton?
Yes.
Okay.
And I think that's Davis County.
All right, that's what I thought. And Prosecutor A was with you?
Yes.
Okay, and isn't it true that while you and Prosecutor A were in Davis County, you learned from Prosecutor A that one of his adult children was at the rally and was texting him about their experience?
Yes, I mean, we had just broken for lunch, and he showed me the text, Charlie Kirk got shot.
And that was a text that he showed you was from one of his children, right?
Yes.
And you knew at the time that it was a text from one of his children, right?
Yes.
What did he say to you? So I'm talking about Prosecutor A.
He said, look at what my child just showed me.
Careful there.
And that's about it. And then
Careful.
he said, I should be getting down to UVU.
Okay, and then he left.
Yes.
And he, as far as you understand, he drove down to UVU.
Well, he drove towards UVU, yeah. He drove in the area.
Okay.
Ultimately, I met him, and then we drove together to UVU.
Okay, so you, according to the pleading that you authored the pleading that was filed.
Yes, I did.
Okay, so that, for the court's benefit, that's the state's opposition to the motion to disqualify. You
Yes.
authored that, correct?
Yes.
All right. And in it, you said that 10 to 15 minutes after Prosecutor A left the event that you were at in Davis County, you left.
Yes,
Did you also head in the direction of UVU?
Yes.
Okay, and then you and Prosecutor A met up somewhere?
Yes.
And then traveled to UVU together in your vehicle or in Prosecutor A's? I guess there's a third alternative, which is you met somebody else and traveled with them.
No. I don't remember whose vehicle it was.
All right, did you talk to Prosecutor A?
It was my vehicle, I'm pretty sure.
Okay.
So.
And was that just about logistical convenience, like let's just go in one car, or was there some specific reason?
Yes. No, that was no other reason.
Okay. And on your way to that, what I'll call the meeting point, did you have any conversations by telephone with Prosecutor A?
Well, yeah, because we needed to meet. He left. I thought I would get some lunch first before I went to the command post. I got about halfway through that and said my mind was not on it. I needed to go to there. And so then we called. I believe I called him or he called. I'm not sure who called who, but then we met. We hadn't arranged that when he left.
Understood. But did he convey to you any more information about his child's experience in those conversations?
No.
Okay. And did you inquire, like, how's your kid or anything like that?
I did not.
Okay. And so you met up and then you went to the command post, which was established near the university, correct?
It was at the university.
Okay. Was it inside one of the buildings?
What's that?
It was inside one of the academic buildings.
Yes.
All right. And did you see Prosecutor A's child there when you were there?
No.
Were you introduced to that person?
No.
Okay. Did you have any conversations with Prosecutor A about whether they should stick around and wait?
No.
Did you?
My understanding, based on, my understanding was that everybody had left. We were told that most of the students had left. They had not, or attendees. So.
Okay, so as far as you know, Prosecutor A's adult child had left the university before you arrived?
As far as I know, my understanding was that, most of the students had fled. That first they went into buildings or whatever, and then they made their way out.
You are aware, I'm sorry, that's not a question. Give me a second, Your Honor, if you would.
Where is this going? So he had like no contact with her at all, had no conversations with him about her. So he made some legal changes based on nothing that happened?
Okay, so did you spend time with Prosecutor A at the command post on September 10th at UVU?
Yeah, they worked together.
Yes. We were going different places, but there would be times that we would meet up. But off and on is all I can say.
Okay. And did there come a time, either on the 10th or shortly thereafter, where he provided you with some information about how his adult child was doing, having been at this rally?
I don't remember him ever saying anything about that, and I never asked. I probably should have, but
it's good you did.
I don't remember any conversation regarding his child.
Was there anybody else at the rally who you are friends with, or is a relative of yours, or a close coworker that you're aware of?
I know that there were some people in my LDS ward whose children were there.
Okay.
Great.
And when you say some people, could you be a little more specific? Like how many different families?
Just members of the ward.
Sure, but do you know how many different families that would be?
I think I was told about 2.
Okay. And who told you that?
One of the families.
Okay, so one of the families in your ward informed you that one of their own children had been there, and then another one had been there?
And that somebody else from the ward had been there.
I see. And do you know who those people are by name? I'm not asking you their names. I just want to know if you came to learn who they are.
Yeah, I came to learn who they are. Yeah.
Okay. And are you close with those people?
We're casual friends with one of them, but I don't think I learned that until well after we had filed the information.
Understood. When did you learn that?
Sometime after. I don't know.
We're just wasting time here.
So the information was filed obviously in mid-September.
Just in 6 days, so.
Right. Okay. And do you know, like, if you saw the children of the families in your ward who you understood were there, if you saw them on the street, would you recognize them?
I would recognize at least one of them.
Okay. Did you ever have any conversations with them or their parents about their experience?
I tried to stay away from that, other than they told me that the one was doing just fine and the other one was shook up.
Okay. And the other one was shook up. I mean, is that the term used, or is that just your way to summarize?
That's my way of summarizing.
What did they tell you?
Having a hard time with it, or something of that nature.
I'm sorry I interrupted you. So somebody told you, somebody who you know from your ward, told you that their child is their child a student at UVU?
Probably. They're young adults, so I'm assuming that. I really don't know for sure. Yeah.
And I think what you said is that they told you that their child was having a hard time with it.
That not their child, but the other family's child.
Other family's child.
Yeah.
Okay, so it was like a secondhand thing.
Yeah.
Okay. And do you know if either of those young people who were at the rally, well, I'll put it this way, do you know where they were in terms of in what I'm going to refer to as the amphitheater area?
I have no clue.
The one who was having a hard time with it, did you share that information with the prosecution team?
I may have. I don't remember. I may have in passing.
Did you ever suggest to any of the law enforcement officers that that person be interviewed because they were impacted by what they experienced?
No. We don't interfere with the investigation. We try to assist. But law enforcement, they identify who they want to locate and who they need to interview, and I leave that to them.
Did the person giving you this information, so this is another adult in your ward, tell you more specifically about what their child and the other child actually saw and experienced?
No.
Okay. So you don't really know much more about where they were, what they saw. All you really know is one of them was having a hard time with the experience that they had.
Yeah.
Okay.
Yeah, so he knows what victims went through. He's the prosecutor.
I understand you said that you don't interfere with law enforcement, but if you learn, even if it's somebody you know through your community, that somebody has suffered some emotional harm as a result of a criminal act that you are responsible for prosecuting, that's not information you would give to an investigator so that they could determine whether or not, so that they could go interview that person.
I didn't consider that as really relevant to the investigation, so no.
And they're not necessarily named victims to the claim. There's thousands of people there.
The fact that this young person was having a tough time with what they experienced is what you're saying isn't relevant? And when lawyers use the word relevant, we got to...
Well, it's relevant to them. As far relevant as to our case, I don't believe so, no.
Okay, understood. Now, there was a point in time in October, I think it was October 20th.
You can see that
where
screen.
Prosecutor A sent Mr. Robinson's counsel an email disclosing that his adult child had been at the rally, providing us with some information.
Yes.
And so my first question is, were you part of a decision to disclose that information?
Yes.
Okay. And were you part of a decision as to how that information would be disclosed or how much information would be disclosed? Like what led to that email?
Well, there was no decision needed as to how much. The decision was to provide the information that we ultimately provided you. And that is not because we believed that there was a conflict of interest, but that was out of an abundance of caution.
I understand it's your position that you don't think that there's a conflict of interest.
But
I think that's clear. All right.
What is the
Did
conflict?
the entire prosecution team, as it was constituted on October 20th, discuss this bundle of information that was being disclosed, or was it just you and Prosecutor A?
I know that me and Prosecutor A discussed it, and he may have discussed it with others. I don't believe anybody else was there.
When you discussed it?
When we discussed it, one of them may have been, or two, I don't know.
But the information that you obtained, sort of if I may, in the heat of the moment back on September 10th in Davis County, that Prosecutor A's child had this experience. And the text messages that went back and forth in the family, that information was shared with the prosecution team, correct? Everybody knew eventually.
Eventually.
Sure.
I mean, yeah, eventually.
Okay, so.
I mean, I only knew the fact that she was there. At the time, I only knew that she was there and that she left. That's all I knew.
Okay. But is it fair to say that you didn't set up any, but I'm going to use a term like firewall, to keep the rest of the prosecution team isolated from this information that one of their colleagues' children had this experience at UVU on September 10th?
So then they're all going to be mad.
Is there
His
a
daughter was
written
there.
policy in your office, either that existed when you arrived or that you've prepared since then, for how to evaluate whether one of your prosecutors needs to be screened off from a case?
You know, I'm not sure. I mean, we have those conflicts that come. I mean, the biggest thing on screening for us is if there's a potential conflict where information that the defendant has, one of our prosecutors has, because that's why you screen cases, is to make sure that shared confidences aren't also disclosed to, shared confidences with the defendant aren't shared with the prosecutor.
But you could agree with me that there are other types of conflicts that can arise other than what we might call the, privileged communication.
There may be. I mean, I think there can be. I can't think of any right now, but I think the rules are pretty clear with respect to shared confidences. You can't, screening isn't the end all, of how you treat conflicts. I mean, generally speaking, we will just conflict out to another office if we feel like we need to. One example, well, I won't go into that, but I mean, we've been threatened before, and there was an investigation, and of course, we conflicted it to a different prosecutor's office, because in that case, we were potential targets of this individual.
Understood. Okay, so you're not sure if there's a written screening protocol, but what you're saying is when we know it when we see it.
Well,
sort of what I'm hearing you say.
Sometimes we do. Sometimes I've had attorneys that felt like they couldn't talk after they've been conflicted out to at least know the victim, but notify the victim that that we were going to switch the prosecution. But there may be, I just honestly don't know. We keep an eye on those things and rely on our attorneys to notify us when there is a conflict.
But you knew as of September 10th that Prosecutor A's daughter attended the rally, correct? Was in the crowd, correct?
Yes.
Heard a shot fired, correct?
That, at that moment, I don't know that I knew that.
Okay, but you know it as of today.
Sure, I know it now.
Read their affidavit.
Sure.
Which says that.
Well, I knew it. Once all of that information was disclosed to me.
Okay. And that they had to, with many hundreds of other people, run for cover and get out of the open space where they were, correct?
Yeah, I don't know that they had to, but that's what they did.
Well, you've seen the video you've probably seen many videos of that day, right?
Yes.
And weren't there law enforcement officers basically directing everybody to leave the open space so that they could
I don't know that I remember seeing those videos of the students or attendees leaving. I mean, I know that they left. I know that they ran away. What we learned later is that the shooter left immediately after the shot. So,
right, but at the time of a shooting, you don't know how many shooters there are, if there's going to be follow-up, if there are explosive devices, like all those things, right?
Sure.
All right. Okay, so let me ask you these questions about, well, instead of giving you a headline, I'll just ask the question. Once you had all of the information about Prosecutor A's child's experience, okay? What they saw, what they heard, what happened to them, the fact that they were separated from their personal property, all those things, okay? What I'm hearing you say is you never really discussed that with Prosecutor A and his family.
No. I mean, I did discuss, I don't know if it was day 2 or day 3. Law enforcement was there on the day of the shooting, the next day, and I think into Thursday or Friday. I don't remember exactly which day. And at some point, I was told that Prosecutor A's child left the bag there.
Okay. But if you never really talked about it with Prosecutor A, about the impact on his child and the family.
I didn't say that. Not on the day of, or, I mean, in the intervening time, he reported a couple of times that he talked to his child and said that she was doing fine. She reported to him that she was not having any issues.
So did you ever ask him, well, what about you? I mean, your kid was at this.
I didn't. Okay. Not that I recall.
Well, if she's fine, then he's probably fine.
Did you ever consult with anybody in the Attorney General's office concerning whether Prosecutors A's child's experience raised a potential conflict of interest for your office?
No, that's what I did for 23 years with prosecutors, is consult on that. And so I didn't feel a need to go to those folks.
Tell us more about that.
Try to figure that out.
So when one of your responsibilities in the Attorney General's office was to consult about ethical issues?
Different matters. It could be a variety of things.
Okay.
And I mean, if you're talking about ethical issues in particular, I don't know that the Criminal Appeals Division was the right folks to consult, but I'm not even sure of who from the Attorney General's office would. So.
Okay, but you worked in the Attorney General's office for a couple decades, right?
Yeah.
And what you're saying is that in your role as an appellate lawyer for the state, you would talk to prosecutors, I guess it's somewhat more informally, about ethical issues.
Yeah, every once in a while, yeah.
Sure. And so my question is whether you reached out to anybody in the Attorney General's office about this particular issue.
No.
Okay. Did you, and when I say you, I really mean you or anybody in your office on your behalf.
Okay.
Okay? Because you're the chief prosecutor, right?
Yeah.
So when I say you, I mean you and people who work for you. What about the Utah State Bar?
No.
I mean, they give ethics guidance to attorneys on all kinds of issues, right?
Yes.
Okay. But no reach out. Other county attorneys in Utah, in other words, your colleagues who are elected chief prosecutors in their counties, did you discuss this with any of them?
No.
Are you a member of organizations of what I'll call chief prosecutors?
I'm a member of the Utah County and District Attorneys Association.
Okay.
UCDAA. I'm actually the president of that organization.
Nice.
I'm a member of SWAP, which is the statewide association of public attorneys and prosecutors. I'm actually the president-elect of that organization. That's a lobbying organization.
Okay. And do these associations have any mechanism for providing ethical guidance to their members?
No. I mean,
he made a judgment
when we
call.
have
He didn't go
questions,
consult with anybody
we
else.
may shoot out an email and ask about things.
Did you do that in this
No.
situation?
I consulted no one other than my team.
Perfect.
Okay. I'm going to
Don't
ask you
need
3 more
any more-
categories, just to be clear.
Okay.
Did you reach
Don't
out to
need-
any law professors who
No.
purport to be
No.
ethics experts?
No.
Did you speak with any judicial officers?
No.
Court reporter, get the question and the answer?
Yeah, last
Oh,
one.
there you go.
Well, I just said that I have talked to no one other than my team.
Yeah, so you don't need to keep
Okay.
asking. What else you got? Watching him scroll around on that computer. Resolution is too low, but watch them object over that. You know, the cameraman can see my screen. He can read my documents.
Did you ever discuss with Prosecutor A whether his child should or should not be interviewed by law enforcement?
No.
It's a good question.
Are you aware of any?
Maybe, I don't remember.
Okay, so that may be important. You want to take a minute to think about that?
Yeah.
What's that?
That may be important. Would you like to take a moment to think about it?
I don't remember. I don't think so, but I do not remember.
Whether she should be interviewed as a victim or as a witness. Have to ask Dad about that. Okay. Looking like he's going through a Word document or something.
The brief that you filed on behalf of the state, I'm sorry, the opposition to the motion has a couple affidavits attached to it, right?
Yes.
Okay. And one of those is the affidavit of Cole Christensen.
Yes.
We just read that.
And which for the court's benefit in the record is addendum C to the opposition. Special Agent Christensen writes in his affidavit that you and he in mid-December, so that's after the motion to disqualify was filed,
Yes.
went to UVU and basically conducted some observations and measurements, right?
Yeah, he was investigating that part. I did go with him because it doesn't involve trial. It's never going to come out in trial. So I did go there and assisted him. But he also had another officer there so that anything that I did could be corroborated by that officer.
Okay, but isn't it fair to say that basically what happened there is you said generally, Mr. Robinson's defense counsel have filed this motion to disqualify. I want to have some measurements done because I want to figure out what risks there were to Prosecutor A's child based on where they were and where you believe the shooter was, right?
Yeah, we have very good evidence of where the shooter was.
Okay, so I want to.
And it was based on Prosecutor A's child indicated where the location that they were, I'll use they, and
too late for that. We already know.
And based on the evidence of where the shooter was, so we wanted to confirm that. Now they didn't know where, obviously where the shooter was, but we wanted to confirm based on, we knew where the shooter was, and so we wanted to confirm that that they weren't in the line of fire. And that was important because that's critical to the state's case, is whether or not someone's in the line of fire.
So she could have been a witness.
Okay, so there's a few things there I
Yeah.
want to try to make sure I cover. And if Your Honor, if there's any point in time where the court or its staff need a break, just tell me, because I can break whenever whenever the court needs that.
We'll be taking a break shortly, but I appreciate that. And if any of the parties do need a break, please indicate it as well. I want to be respectful to all parties.
Thank you. So the first thing I want to address, Mr. Gray, is that you knew that the defense had filed this motion to disqualify based on the relationship between Prosecutor A and somebody who was at the rally.
Yes.
And had the experiences that the court has already heard about. And so you basically went out with a law enforcement officer and you did an investigation and took a number of measurements.
He did, yes.
Okay, but at your direction, right? Because you're the one who
I asked him to do that, yes.
Okay.
So is she getting special treatment and investigations around her? Does she have some special connection to the case? Why is she getting a special
you say in
cop going out there and
connection with
measuring
that,
things?
That there are some uncontested issues in this case.
Yes.
That's a term you used in your brief, right?
I'm sure that you will tell me where they're not contested, but.
Well, every issue is contested, right? I mean, the
So
state
is it, okay, go ahead.
I'm not trying to.
Charlie's dead.
Have
Are we
a
contesting that
argument because the court reporter doesn't like.
I
to speak
stopped,
over each
so
other.
I'm not.
And I'm bad at that too, and I have been for a very long time. But your measurements, as documented in Mr. Christensen's affidavit, Special Agent Christensen's affidavit, are of things that you say are uncontested, but I just want to make sure.
So can I clarify that? I never said that the measurements were not contested. I said what was not contested is the fact of the things that Child A could testify to. That's what I was referring to as what's not contested. Child A, as demonstrated in the affidavit, can testify that Child A was there, that her Child A's location, and what the crowd did, what she did, and then what she ran in. That's what's uncontested.
But aren't these also uncontested things which you contested issues which you seem to suggest to the court are uncontested, and that is that the shooter was on the roof?
No, I didn't say that was uncontested. I said what she could testify to is uncontested. And if there was something different than that, that's certainly what I meant. I understand that all those other things could be contested.
Okay. You've made yourself a witness to evidence that you've used to try to advocate to the court that there's no conflict of interest, right? I mean, you basically, even though you're representing the state, you went out and you participated in a what you hope is a systematic way to measure whether Prosecutor A's daughter was in a line of sight from the place where the state alleges the shooter was, right?
Sure.
Okay.
But as far as making myself a witness, I was careful to make sure that there was Cole Christensen and then an officer from UVU. If you look at the case law says that prosecutors can participate in these interviews and so forth. What we do is make sure that someone else is there so that we don't have to testify. And the defense can't force the prosecutor to testify under those circumstances. That's the case law.
And it won't surprise you that competent defense counsel have the same practice. We don't interview witnesses without investigators present.
Right. And this was no different than that.
Understood. Okay, I do want to address another aspect of this.
Hopefully it's about the consequences of what
line of
this
fire situation. Okay,
That's not
so
gonna
it's
be-
the state's theory of the case, if I may, that the shooter was on a rooftop, correct?
Yes.
Okay. And what's the name of the building that the state believes the shooter was on?
I don't recall.
Okay. And so these measurements that are in Special Agent Christensen's declaration, you're saying were designed to basically, if I may, I'm not trying to put words in your mouth, rule out whether the child of Prosecutor A
could have been
is in some ways a victim of this incident.
Not as far as a victim. We already understood that, based on where the buildings were, that the child was not in that line of fire, but we wanted to provide the measurements for this motion.
So what is the significance of the measurement? What is the significance of whether the child of Prosecutor A was or was not in a physical position where they could have been shot? What is the significance of that?
The aggravator, as you know, is that we're alleging that when the shooter killed Charlie Kirk, that he placed others in grave risk of death.
Yeah, but if you're analyzing her,
so anybody
a part of the
within
case,
that zone, if you will, was placed in grave risk of death.
Okay, and so you've now gone out and you've done these measurements from the place where you believe the shooter was, and anybody who's positioning at the rally, there's no line of sight. You're basically excluding all of those people from being among those
who are in the line of sight who could have been shot. Yeah,
That's our understanding. We'd have a very difficult time proving that others beyond that point were also in that line of danger. I mean, we could, I guess, we could make the argument, but that would be difficult to prove.
And so is it your position that because this adult child would not fall within the category of people to whom the aggravator applies,
that she's not a relevant witness?
There's no other connection between those people and the prosecution?
Not the crime. I mean, again, depending on whether, again, I rely on law enforcement to provide us with whether they have something helpful or not. We were able to determine based on what the prosecutor's child, there was nothing useful. There was no need to provide anything. I mean, we make those determinations when they provide it to us all the time.
Did you work with Special Agent Christensen on his declaration?
On what? No.
On his declaration?
I didn't.
Did somebody else?
Yes.
Another one of the members of your prosecution team?
Yes. That's generally the practice.
Okay. Was it Prosecutor A?
No.
Okay. Now, we've also, I should say, you also filed with the court Addendum B to your opposition, which is the affidavit of the child of Prosecutor
Yes.
A, right? And
which we read.
This person is a young adult who is a student at the university, right, at UVU?
Yes.
Okay.
That's what I'm told.
Okay.
I have no reason
Did you
to doubt
speak
that.
with this adult child in connection with the preparation of their affidavit?
I did not.
Do you know who did?
I do.
Who was that?
It was Mr. McBride.
Okay. And do you know whether Mr. McBride consulted at all with Prosecutor A about that?
I couldn't answer that. I don't know.
Okay. Did you read the affidavit?
Of course, I wrote the opposition. I better read the affidavit.
Did you play any role in the shaping of the affidavit in any way?
No.
It was just given to you, here's the affidavit.
Well, I mean, we were aware of what the student, I'm going to call a student now.
It's fine.
We were aware with what the student had said as far as what the student was aware of. And so we obviously, as I started writing based on what my understanding of that was, and I'm sure that Mr. McBride covered those areas to make sure that we were accurate.
Are you saying that the affidavit followed from your briefing and your briefing was based on your?
No, that's not it. My briefing was based on what the information that the student provided. And so to that extent, I'm sure when Mr. McBride talked to the student, that he would cover those things.
Okay, so what I'm missing is, where did you get the information about what the student experienced if you had not seen the affidavit?
That was from the prosecutor that is the parent of that.
Okay, so Prosecutor A told you this is what happened with my kid.
Right, I mean, I think that's pretty established.
All right, Mr. Novak, this
Yes,
might
sir.
be a good time to take a brief break.
Whatever works for the court.
And just not meaning to pressure you, I'm just trying to anticipate how much more time for questions you have for Mr. Gray, just for housekeeping purposes.
It's 4:06 according to this monitor. Oh, that's not right. It's 5 o'clock.
Yeah.
The monitor says it's 4:06. That must be some time zone that somebody else lives in.
He's got another 5 hours, this dude.
At least another 20 minutes.
All right. So we'll take a 10 to 15-minute break, and perhaps council can confer in regards to housekeeping how we wish to address the remainder of the witnesses, whether in a setting today or a different setting. I'm not saying which way, but if you wouldn't mind consulting, and we can discuss that briefly when the recess is over.
That's fine. Do you want to give us some guidance on what works for the court and its staff? Because, I didn't know it was 5 o'clock, but it is.
Right. Go ahead and discuss that, and I'll talk with staff as well. That it gives me time to speak with them, and then we can confer
Very well.
with that. All right.
Thank you.
Court will be in a brief recess for 10 to 15 minutes.
All right, so I think we'll probably call it at the end of that right there, because they're just going to spend probably another 30 minutes on a break, and then they'll come back, and who knows what they're going to do. So we'll probably not finish today. I think we're going to have a lot more witnesses, including the daughter and the actual father themselves. So I think we'll probably come back, do 20 minutes, and then we'll wrap. But they could be here for another hour. All right, so let's see what you say about it. This was a wild day. Honestly, was not expecting this to go on. They wasted about 3 hours talking about the hearing before we even started the hearing. Then we had Mr. Cameraman himself, who apparently almost got the case dismissed, which is a big problem, but it's been a doozy. All right, let's see what you say about all of this. I saw some comments come in. The court is on break now. This old guy says, I think the whole conflict of interest thing is a wild goose chase on the part of the defense. I agree. Honestly, I do not know why this judge is even indulging in this right now. If the prosecution, went aggressive to go defend this daughter, then maybe you'd say there's something weird there. But it sounds like they sent the guy to go measure after the defense was already raising the motion, right? So they're like, well, let's just go show you exactly where she was and why she's not even a relevant witness. So the investigation into her was to show that it's not a big deal at all. She's not going to be useful to you in any way, shape, or form because she wasn't even in the right zone of the line of sight. So I was waiting for this guy to give us some consequence. Oh, okay. So Mr. Prosecutor, since you know the other prosecutor, that's why you charged him with this. Or your decision was to bring charges like this, but after you spoke to them, then you changed it, right? So that the conflict is apparent or that it's even in alignment. Think about Fannie Willis and Nathan Wade. She's paying him, they're going on vacations. So she's getting a benefit from the conflict. what is this guy getting as a benefit from the conflict, and what is it that caused that benefit? What's the nexus? It's, I guess, the fact that she was just there. Well, many people were just there. He has an obligation to prosecute anyways. It's not like Fannie had an obligation to go on a cruise with the guy, right? So what is the appearance of impropriety? It's got to be something legal that happened. So is it the death penalty? Is it an aggravating factor? No, she wasn't even in the area where the aggravator would apply. So it does feel like a wild goose chase. We'll see if they come back while we're here, but it's been a long, brutal hearing. Yeah, too bad it's a public trial, says bass player. Good to see you, bass player. Hey, Jarbot, thank you. Rob, they're back. They're back. Smooth Brain Crypto, talking about the Case versus Montana case. I did have a chance to look that up. It was a solid 9-0. They didn't kill the guy. They just went in there and shot him. And then they went into the house. Apparently this guy was having like a suicidal breakdown. And then in the breakdown, he pops out of a closet, is going to, I think the cops say he was assaulting the cops. Then the cops shoot him. Then they charge him with a crime after they shot him. They charged him with assaulting an officer. So then he goes to trial, loses, and appeals, says they can't just break in here when they think that there's exigent circumstances because somebody's going to be harmed. The girlfriend called the cops, of course. That happens all the time. I represented so many people. So many girlfriends would come in with their boyfriend, and they're like, oh, so sorry, I called the cops on you, baby. He's like, I know, I'm going to prison now. She's like, I really wish I wouldn't have done that. Is there anything I can do now? Nope, too late. Sorry, you called. So crisis over at the border. Trump's new boulevard at the old Southern Boulevard, of which runs through very bad areas, but it's going to be great. Once that road comes through, they're going to just be so happy to be living on Trump Boulevard. Has Robinson even entered a plea yet? I thought this was supposed to be the prelim probable cause hearing. No, I think that's coming up next. I think we had that date. Yeah, I think he's entered a plea if not guilty. But yeah, then the preliminary hearing, look, that's not even scheduled until May. Look at that. The prelim. I think that was tentative though. So next court setting, I mean, I think we're going to be back tomorrow or whatever next week on this. I'll have to continue this because they're not going to stay for another 3 hours for another 3 witnesses. So I think they'll probably call it. But yeah, my understanding is he pled not guilty. He had the closure hearing, status conference, waiver hearing, initial appearance. Yeah, pretty sure. Pretty sure he has. Unless we missed something. But yeah, so anyways, great comment. Thank you for that. Then from Jarbot, what's up? KX250FMX. Hey, Rob, regarding the good issue, would you as a defense attorney consider using an argument of the ICE officer put himself in a position where there was the potential of being hit? No. I mean, a defense attorney for... Are you saying like he was like assuming the risk, like an assumption of the risk, or he had some comparative fault or some like, contributory negligence or liability? I would say no. He was doing his job. His job was to stop a person who was given a lawful order to get out of her car. So he came out in front and was detaining her. So despite being within his agency protocol and procedures, this has come up on different podcasts, and I found it to be an interesting and very polarizing issue. Yeah, no, he definitely did get in front of the car. But yeah, I mean, he was detaining her, right? That's the point. He's getting in there to block her from leaving. She doesn't have an option of just running him over. Now, like if it was a negligent, like that's a cop, he's got lawful authority. He's got, he's a federal agent. He's got authority. He's there executing federal law. So it would be different if this was a civil case between 2 civilians. Like if you jumped in front of somebody's car and got hit and then you sued them for that, they would say you jumped in front of the car, stupid. You didn't have a basis of stopping that person from, running. But also if that person ran you over, like you really can't just run over people because they're in front of your car, unless it's like Florida and you have that, driving law. You can just run over the protesters or whatever, which is great. So I think that no, yeah, he got in front of it. Maybe you could say that's not wise or it's not, it increases your risk. But how else do you block a car from somebody who's fleeing? And yeah, I mean, you might even say he wanted to get in there. He's instigating it. He's done it before. He got dragged before. He was instigating this, right? He was trying to increase the tension or whatever. You can make all those, I think, arguments, but it doesn't negate the law, which is you can't run over a federal agent, no matter where he's standing. If he's standing in front of you, it's easier to not run him over because you can see him right there. So, and it's like, he's got the one up on that. He can outmaneuver you because you are not allowed to hit him with your car. So yeah, great comment. Jarbot, good to see you. The Real Chase. I'm still shocked from this ruling by the Central District ruling of California. We covered that this morning. Yeah, we read that one this morning. What do you think of the district court ruling about the California gerrymandering? So we read that this morning on the members only stream, The Real Chase. We covered the whole thing. You're a membo. We read through it. I don't know if we read the whole thing, but we actually read more of the dissent and agreed with the dissent. That's the one we read this morning, right? Yeah, so check it out, The Real Chase. We went through the whole thing this morning on the Membo stream. Silly Rob, Rick D, good to see you. Mrs. T. Rush saying, don't condemn people. We have a presumption of innocence. Crisis over at the border, good to see you. Case versus Montana. Jarbot, nice to see you. Bass player, what's going on? Our taxes paid for all of this. Live stream 24/7 in court. They should not turn it off, is what you're saying, Golden Gaming. 26 months as a membo, coming up on multiple babies there. Thank you for that, Golden Gaming. We also got Crisis over at the border says, hey, just saying, we all chip in $20 and we let Rob provide a synopsis. This has been dreadful. Yeah, I think that's where we'll leave it. We'll see if there's anything else that is good that comes of this. But that attorney, honestly, we may not be able to do these live anymore because it's just so painful. They all talk like at 1 word per minute. What's going on up there in Utah? Is everybody up there like in 0.75 speed? What's going on up there? Turn up your speed on your play button. Benny Boy, Rob, do defense attorneys bill by the hour? Yeah, many do, although some also bill by a flat fee. So it just depends on your attorney. And this guy apparently has got an attorney who will spend all the hours in the world just getting through one single sentence. It was brutal. Hey, former LEO, why don't they just have Robinson wear a Jason or Hannibal Lecter mask to shield his lips? Easy peasy. Yeah, or just do like all of the college football players, or college coaches or whatever. Do a show like this. You guys can't even, you can't hear. You have no idea what I'm saying right now. None at all. Because you can't see my lips moving and it's being blocked right now. So you don't know. Former LEO, what's up? Hey, good to see you. Rub some dirt on it. As a prosecutor, shouldn't he have a better grasp on how to answer questions in court? Yeah. The idea, like a legal argument that I'm just not a good attorney and I'm going to screw up, so I don't want the public to see that, it's not a good argument. Well, this is the show. It's like you're an actor, you're going to host a play, and you don't want to perform because the audience might not like you. Well, that's the show. That's the play. This is the court hearing. So go practice at home in front of the mirror and come back tomorrow. Mock Schnell, what's up? 20 membos coming in, courtesy of Mock Schnell. Waffles, bacon, welcome. Mock Schnell, thank you for doing that. You're awesome. We'll have a members-only morning stream tomorrow on Saturday. It's going to be the best one ever. Christopher Bell, what's up? T-Rex Travels. We got Boo Man 1. Bo Man 1. Carl Stevens, Live to Give. What's up, Flicks Punk Rock? We got SC Dogs Fan. Colleen Page. Casey Athau. We got CV Grady. What's happening? Mock Schnell. End of week membos. Brian McDonough got one. We got Lost Tunes. James Crofts. What's up, Orca Blows? Brian Bentley. Joanna O'Brien. Bob Barnes. And David Taylor. All gifted membos courtesy of Mock Schnell in the house. Thank you, Mock Schnell, for doing that. And yeah, there you go. So we're still waiting to see if they come back. This old guy. I think the whole conflict of interest thing is a goose chase on the part of the defense. I can't imagine the judge is going to disqualify the entire county attorney's office over this. Remember what Fannie Willis did? They didn't even disqualify her. I mean, they ultimately did. But at the lower level judge didn't. He's like, well, just as long as you can get rid of the odor. Just open up a window and let that noxiousness escape. Mock Schnell, 20 more membos, Mock Schnell? You're amazing. Look at this. We got Football Jones. SGNL Gaming. We got Big Guy Guido in the house. Notorious Network is here. Voss Lori. What's up, Doorman? We got DB Crypto. Lore B is here. Jory. Smoky Mountain Lady. Tech the Terror. Jules in Minnesota. We got Conley Judy. Sharon Lee. What's up, Barbara Neely? Kat, we all just get along is here. Kelly McCammon. What's up, TJ? T. Jart Izzard. We got Adam, Terry D, and Douglas the Corgi. All gifted membos courtesy of Mock Schnell in the house. Dan says, Rob, 4 hours? Ugh. I know. Honestly, I was thinking about it. I was thinking, well, what if we just did the show at 3 and then we could just do a recap? And I was like, well, it's not going to be done at 3. So then we'll be jumping in live, and it's when we normally go live, and then we'll just jump in the middle of the hearing. So let's just start early and we'll just cover it and it'll be done. And it just kept going and going and going. Gosh, Dan, it's not even over yet. Dan, remember, this isn't even the trial. No, this is a threshold issue. This is a qualification or disqualification, the ability of the prosecutor to even be on the case. That's how early in this whole thing we are. Thank you, Dan. What's up, Leonard? At this very moment, Dems are looking for a lie that they and the corrupt media can exploit. Yeah, and what are you seeing out there with the media? Are you thinking they're like defending Tyler Robinson? Are they saying he's innocent? Are they saying he's guilty? That Utah got the wrong guy? Like, what's the mainstream saying? We know what other corners of the internet are saying, but Concert Chick says, talk about drawing out the case. Oh my gosh. Not only draw it out with challenges, but drag the questions as slow as humanly possible. They're still just going. Dan Sundin, they want their words to be correctly heard and recorded by the court reporter. Well, they can speak with a little speed to them. Bonnie says, this is the worst defense litigator I've ever witnessed. Not all attorneys are good litigators. Yeah, I mean, I think he's stylistically, it's just painful to listen to. But honestly, this judge is just like him. And so is the county attorney. So maybe this is just how they are up there in their courts. All of them super slow. And I understand wanting to slow down for the court reporter, but you don't need to wait 3 seconds between every other word. I almost forgot. Go Niners, says former LEO. I think there's some football or something going on this weekend. The president is also going to be, I think, traveling to a football game this weekend. We looked at that this morning on the members only morning stream, which was great. We'd love to see you tomorrow on the members only morning stream. Hey, we got some other comments before we wrap on the day. We got Dana says, have we spoken about Trump cutting off federal funds? Yes. To the states that have sanctuary city policies? Yes, we did. Personally, I receive funds from these programs, and just think about all of the elderly, disabled, and families that rely on those funds for housing as well. Yeah, no, it's going to be brutal. Yeah, it's going to be brutal. Are you in a sanctuary state, Dana, in the house? See the Veil says, most of the states affected, like mine, put a plan in place to ensure funds to the people who didn't get harmed. Yeah, I mean, I think, you know, the states shouldn't be giving the money to the illegals, and then it can go to the people who need them, like you, Dana. Says, I don't know about all the states, but I do know most are prepared for this because they know the elderly and the disabled were not at fault for this. But again, I don't know how many states are able to handle the cuts. Also, too, what other tools can the federal government use so that the vulnerable are not harmed? It's deporting the illegal aliens and kicking them off all of the programs. And if the sanctuary cities want to pay for the illegals, then they can pay for the illegals, but we're not paying for it. And if that comes out of the state funds in order to do that, then there needs to be political repercussions for that. Just call your representative, call your congressman, call your state congresspeople, call your state representatives, call your governor and their office, and explain that there will be political consequences for this if they keep funding illegals. The Veil is here, talking about Scott Ritter, UN's weapon inspector, and being debanked. Man, hopefully Congress can do something about the debanking, says The Veil. Long post over there about a former Hollywood actress and all the people who are being debanked. It's not good. Not good at all. Yeah, and apparently, for the court reporter, this old guy says, apparently court reporters in Utah take their notes in longhand, in cursive. Yeah. What's going on, baby Lewis? Yeah, I just live outside of Chicago, says Dana. Media loves Donut says, no one knows anything. In fact, I think part of it, Rob, is wrong. If there was any evidence the officer tried to block the car intentionally, it opens up a real argument, especially given a recent Supreme Court case. But there is no evidence his positioning was intentional. So you think there's a Supreme Court case like, I don't think that cops can't cause, certain things that then cause them to shoot you. But he wasn't trying to get hit by the car. He was trying to detain her. She made the decision to hit him with the car, which is how I would interpret it. Just because he's standing in a location, like, okay, like say a cop is like standing in front of a Walmart and you're stealing and running out of the Walmart. Does the cop have to get out of the way if you run him over? No, the cop stands there. You hit the cop, you're charged with assault for that. So like, is there a duty to retreat for the cop because you're in a car? I just don't think that makes any sense. But I think that there is other case law that says that, yeah, the cop can't use unreasonable force, like strangle you to death, like strangle you, then you fight back because you're getting killed. Then the cop shoots you and then blames you for the whole thing. Like the cop can't cause the breach, cause you to react, and then you shoot that person. But in this case, the cop was just standing there. He didn't like force her to drive into him. And it wasn't like she was already driving and he jumped in front of the car and then started shooting. She was stationary. We saw the vehicle set back as she was accelerating into him. So she made the volitional decision after he was in front of her to move. And that's, I think, where the problem is. Yeah, bad lawyer, number one way to appeal, too. Phone is buffering. Bonnie, good to see you. Worst defense attorney you've seen. I blame her obnoxious idiot partner for screaming, "Drive, baby, drive." I think she would have stopped on her own if it hadn't been for that. Sadie just shared a link. Yeah, and apparently the family just hired the George Floyd lawyers. And Minneapolis, I think, settled with George Floyd for like $29 million. Remember that? So I'm sure her family will get a big fat payday because Minneapolis is happy to pay for people who do stuff like that. Yeah, lawyers and attorneys think that their ideas and words are so important. Oops, this isn't personal, Rob. No, it is true. A lot of lawyers really think way too highly of themselves, and it's not justified at all. This old guy, apparently court reporters in Utah take their notes in longhand. And, yep, they're still going on. So I think it's probably a good time to leave this one here. And, of course, we can debrief later on after we learn what the court ultimately decides on this. I just have a hard time thinking this judge is going to disqualify the entire Utah County Attorney's Office. Seems like a stretch. All right, so there, my friends. I think we'll wrap it on the day, and we'll see what else happens here. Bonnie's going to the pool. Yeah, good call. It was a SCOTUS case where a cop jumped on the side rail of a fleeing vehicle and then used that in order to shoot the driver. Yeah, so the vehicle is already fleeing and he jumped on the side rail. So for example, for that, he's trying to stop a fleeing felon, right? Now he's not in risk of injury, imminent injury. So in other words, he caused the situation. The car was already a fleeing felon. She wasn't a threat to him in the fleeing car. He caused the threat to himself by jumping on the side of the car in a car that was already in motion, right? Something like that. This was not that. The situation was stopped. Then she accelerated and put him in apprehension of imminent harm. So he had to exercise reasonable force and he shot her and killed her. So that's how I would distinguish the two. Boopsie. Yeah, and imagine if she realized she's responsible for her death because the spouse was screaming at her. Yeah, good stuff. Dan, I have videos of ICE trapping a car with other vehicles to make a capture. We might have to do another deep dive on this. This sounds like some good questions and some good convo. Christy Katz, good was wrong, along with her wife telling her to drive, baby, drive. But if you walk in front of a vehicle, your body can't stop that. Why didn't the ICE guy just tase her? Well, because you can't shoot a taser through a front windshield. And yeah, walking in front of a running vehicle can get you hit, but he has protection of being a federal officer. So you're not supposed to hit federal officers with your vehicle. I think basically everybody knows you can't run over cops. So his authority should have stopped her from doing that. And she didn't. Not good. I wish she wouldn't have done that. I wish she was still alive with us. Genuinely, it's terrible. But she's got kids and all the things. Officer drew his weapon, preparing to cover the officer as removing her for the vehicle, says this old guy. Yeah, and her whatever girlfriend or wife, whatever, isn't family member, so we'll see if she gets any part of that settlement. She might. Are they married officially? Yeah, good stuff. Okay, so my friends, let's pause right here. They are still not back, and when they come back, who knows how long they'll go. There are some other clean feeds out there. If you just search for Tyler Robinson, you can catch the rest of it. But honestly, this was one of the more painful court proceedings that we have covered here. Very slow, very repetitive. I don't think the judge should have indulged in most of this stuff, but he did. Dan, I have videos of ICE trapping a car with other vehicles to make a capture of a criminal illegal up in Minnesota. I'll find that video and post in the newsfeed. Yeah, so you can't cause the threat to you and then kill somebody or shoot somebody after you cause the threat on yourself if you're a cop. But he didn't. He was just he was doing his job. He got in front of her, got in front of the car. She decided to accelerate. He was standing there and had to defend himself. And, maybe he didn't have to defend himself, but I think was legally allowed to defend himself. He easily, I think, probably could have done a barrel roll and ducked out of the way. But you don't know at that moment that she's turning her wheel, and she may not have turned the wheel until, the gun came out. She's like, oh, crap, and then turns the wheel to try to escape. But I think the Supreme Court analysis that Donut Mind Me, maybe you would say is better, would be for the side shots. Like maybe the first shot through the windshield would be okay, but the side shot. But I think as long as he was justified on the first shot, she's a threat. And it was also close in time. He couldn't have known whether she was turning left or right. We'll see if he gets charged. I know that they're working overtime to figure out how to do it, but he's a federal agent, very different than what we saw with Derek Chauvin. So he's got all sorts of immunity and protections. Anyways, all right. So my friends, it's been a beautiful stream. Thank you so much for being here. Thanks for hanging with us long. This stream was not exactly what I expected it to be. So my apologies that the case was so boring today, but we'll keep our eye on it. I do think it is an important case. We want to make sure that we're paying appropriate attention to it and watching the watchers over there. All right, so we'll pause here for the evening, and members, we'll come back tomorrow morning. We'll get into it again. Thanks for subscribing. Thanks for liking this video on your way out. And members, hopefully we see you back tomorrow. Otherwise, my friends, we're coming back on Monday. Before we wrap, big thanks to our amazing mods and meme smiths, all modding the fort down for us, keeping things nice and orderly. Court is still not back in session. Big shout outs to Donut Mind Me. We got John, Muffin Rando, K Bean, Carrie B in the house, modding the fort down for us, keeping things nice and orderly. Oh, and East Idaho actually turned it off. Wow, so they're not even on the feed anymore. Everybody's had about enough. All right, so Neuro D, Janek, Dog Digger, Geegum Geegum, Elliot, Just Rhonda. I think we got everybody. Thanks for modding the fort down for us and for being here. It's been a good stream, but I don't even know. Are they coming back? Here, let's just see. Let's see if Forbes still has it up. Looks like Court TV nuked it. Milwaukee Journal Sentinel is still live, but everybody else is bailed out. East Idaho News bailed out. All right, yeah, so it's good call. We'll bail out, and we'll debrief anything else that's going on. We'll come back. We'll get into it again. All right, my friends. Beautiful stream. Thank you for hanging with us. Thanks for subscribing on the way out. All the things. I think I've already said this many times, but we'll call it a day. We will be back on Monday to get into it again. And in order to do it appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Happy Friday. Sleep very well. We'll see you right back here on Monday. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chatting line. Together we exposed corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers, shining the light. Watching the watchers, defending what's right. Watching the watchers, stay